Yes.
May it please your lordship. With the consent of the other side, I beg to mention item number 9, your lordship.
9.
Yes, your lordship. In this case, I could not contact the client. So may I pray for 2 weeks time, your lordship?
Last occasion also you have.
Yes, your lordship, but I could not, your lordship, because of the change of address. I'm trying, your lordship. Lordship will give me 2 weeks time. In the meantime, I'll contact the client and I'll get the necessary instructions.
Mr.
Arsina.
Arsina, learn counsel for the petitioner. The mistake. He still could not contact the client. Contact the petitioners. Therefore, he prays for listing the prays for adjournment matter to adjournment of the matter for further 2 weeks. Praise the Lord. List after 2 weeks.
Deeply obliged.
May I please, your lordship?
Yes.
With regard to item number 52, lordship, I have
Yes.
to take fresh step, lordship. As per Logima, I could not take, lordship. Pray for 1 week more time to take the steps, lordship.
52.
Yes.
Mr.
SS Rod.
S.S. Roth. 52.
52 and
Your name is not there.
not there, lordship. I am appearing, lordship.
Mr. S.S. Roth is granted further 5 days time to take fresh steps
Lordship.
as directed by this court.
Obliged.
May I tell your lordship?
52 and 53.
Yes, your lord. Thank you.
I have to mention item 60. Perhaps this matter may not be before your lordship.
60.
60.
Why?
Earlier round of litigation, your lordship was appeared, I heard. It was an instruction received from my brother.
Are you sure?
It was informed by the leading counsel yesterday. That's why I'm-
Appeared as a what?
as a additional
Against you or against in your favor?
in favor of government.
Yeah.
Yes.
List this matter before any other judge without me.
There is an interim order. That can be
Cannot do
contacted.
anything.
Obliged.
May I please, your lordship? My
Yes.
lord, with the consent of the petitioners counsel, my lord, may I mention item number 13, my lord?
1-3.
My lord. He said 2019 matter, my lord. I need 1 week time just to take some present status.
What is the matter?
It's about cancellation of my dismissal of dismissal from service.
Okay.
But, could it be fixed on 5th of my lord, November, my lord? 1 week.
On the prayer, Mr. S. Rabba.
Yes, my lord.
S.R. Rabba, counsel for the standing counsel BTC.
My lord.
List this matter on
5th of November.
05/11/22.
Highly obliged.
May it please your lordship?
Yes.
I beg to mention, with the consent of the other side, I beg to mention item number 67.
67.
The conducting counsel would not be able to appear today due to some personal difficulties, lordship.
67. What is the matter?
Lordship,
Anyway, on the prayer of Miss M.S.
S. Sharma,
S. Sharma, learning counsel, appearing on behalf of
D. Chaudhary.
D. Chaudhary, learning counsel for the appeal. List this matter after 4 weeks.
Obliged.
May it please your lordship?
Yes.
Your lordship, I beg to mention item number 45 of today's list, your lordship. My prayer is-
45.
Yes, your lordship. We are for the appellant in this case, your lordship. My prayer is that your lordship, this matter may kindly be taken up after 2 weeks, your lordship.
For the prayer of M.S.
P. Bodhapur.
P. Bhattakur, learning counsel for the appellant. List this matter after 4 weeks.
Obliged.
May it please your lordship. Lordship, I beg to mention item number 56, lordship. I am appearing on behalf of S.R. Gogol for the petitioner advocate.
56.
56, lordship.
This for orders, what is to be done?
Lordship, petitioner advocate repeatedly tried to contact the client but could not contact the client, lordship, and we didn't give it any further instruction from the client, lordship.
On the prayer of M.S.
J. Shoikia,
J. Soikia, learned counsel, appearing for Mr. S.R. Gogoi,
S.R. Gogol, lordship.
learned counsel for the applicant of the petitioner. List this matter after 6 weeks.
6 weeks, lordship. Obliged, lordship.
May I please your lordship? Your lordship, with the consent of the other party, I beg to mention item number 42, your lordship.
42.
Yes, Your Lordship, the conducting counsel is not available today due to personal difficulty, Your Lordship.
MS
There is an interim order.
RM Bora, Your Lordship.
Arambara, learned counsel, appearing on behalf of Mr. M.
A,
Vishwas.
Mr. A. Chalia, Your Lordship.
Huh?
A. Chalia for the Finance Department, Your Lordship. Conducting counsel.
Actually, and Standing Counsel Finance Department. Some extent. Mr. Chelia has learned counsel has some personal difficulty. Therefore, faithful listing the matter after
2 weeks, Your
2
Lordship.
weeks.
Interim order may be
Right,
notified.
hello. Please stop it.
Interim
Mr.
order.
So and so, learned counsel. B. Chaudhary.
I'm appearing on behalf of B. Chaudhary.
B. Chaudhary. Mr. So and so, learned counsel, appearing on behalf of B. Chaudhary. Is present. Interim order passed earlier. Continue.
Here, Your Lordship. I beg to mention item number 29 of daily list with the person of opposite party.
29.
29.
Yes. What do you want?
I want adjournment today.
This is your for
I am for petition, my Lord.
Ali.
Ali.
Mr. On the prayer of Mr. MD MS Ali.
Yes.
And counsel for the petitioner. List this matter after 6 weeks.
May please, Your Lordship. Lordship, with the concern of the, I am appearing in item number 54, Your Lordship. I am appearing for response number 1 and 2. I have taken the concern of the petitioner, Lordship.
54.
54, Your Lordship.
Yes.
I am for response number 1 and 2, Your Lordship.
Yes.
I am praying for a little accommodation for today, Your Lordship. Let the matter be listed after 1 or 2 weeks, Your Lordship.
On the prayer of Mr.
DJ Das, Your Lordship.
DJ Das, then counsel for the respondent. List this matter after 4 weeks.
Lordship, actually, Lordship,
3 weeks.
I have given my word to my petitioner, Lordship. That's much of that.
May please, Lordship, I beg to mention item 15, Lordship.
15.
15, Lordship. The matter is in infectious.
Yes, 14, 15. 14, 15. Both.
I am the 15, Lordship.
Who is for? You are in 14.
15.
Who is for 14?
Under 14 to council. Infectious.
In view, you just said what is that rule or act? In view of the repeal of the what is that? Muslim marriage, divorce,
Muslim marriage and divorce registration.
just give that name of the act.
Some Muslim marriage and divorce registration.
1935.
1930.
Just find out. Just give it the detail. I mean, full district. Assam Muslim Marriage
And divorce
Divorce
registration.
Registration Act
Act,
1935.
1930.
Are you sure?
Yes.
The matter has become infectious. Accordingly, the petition is still dismissed as infectious.
Deputy.
Same order.
May,
Both.
may please, Your Lordship.
Mr. You are N. Ahmed. Item 15, huh?
15.
Then item 14, Mr. R. Sharma.
May please, Your Lordship. Lordship, with regard to item number 10, Your Lordship.
Separate order.
Lordship, with regard to item number 10, Your Lordship. Here also I am appearing for the respondent university, Lordship.
Yes.
Here the petitioner have challenged the relieving order and they have filed an appeal before the executive council of the university.
Yes.
Lordship, I need some time to get the instruction. What is the status of the appeal? They have
Overtake over the telephone.
Lordship, at least 1 week time, if it is given, Lordship, then I can bring at least something, Lordship. Actually, so there is a
Release the person. You have not allowed him to join other job.
Lordship. There are something, Lordship. I will not like to pace it now, Lordship. There are some.
Who is for the petition?
Lordship.
I'm appearing for
Petitioner.
petitioner. And then since 2018,
That I have,
and their
Are you
contention is
working?
no. Thereafter I face lots of difficulty working in some private organization now.
You are working in
So
private.
yes, somewhere else I am working. That is the difficulty.
actually, Lordship, the lien was not given by us because
Just
he was
because
not
your
confirmed.
appeal has not been disposed of.
That instruction I have to take,
Allow
Your
the,
Lordship. And more, there is a condition that within
Petitioner
every
to
4
suffer.
weeks,
Yes, he is
You
suffering.
sure that way you will have to
Yes, Lordship. I totally agree that Lordship. Out of a sudden it came, Lordship. Lordship, at least 1 week time.
His appeal will be dismissed.
Let it come on next Monday, Your Lordship. Yeah, Lordship. Scissors to scissors wife concept, Your Lordship.
Next Tuesday.
On the
Yes,
prayer of Mr.
DJ Das, Your Lordship.
Then counsel appearing for respondent 1 to 4. This matter after a week so as to enable him to take instruction as regard the appeal of the petitioner.
Status of the appeal.
The status of the appeal filed by the petition.
Petitions.
Mr.
As for
S. Bora, learned counsel for the S. Barali, learned counsel for the petitioner, has no objection. No, is present.
can a fixed date be given?
After
Can
a
it be
week,
on 5th, my lord?
after the week,
5th of November, my lord.
after a week, you just give the date.
5th of November.
6th of Lordship, 6th. I have some difficulty. Lordship, my senior will be not there.
Then
Or the 7th or
7th I will
8th,
be out of session.
or the 8th, 8th,
Make it 5th.
7th and 8th.
It's not
Then on 12th.
12th, Your Lordship.
12th.
On 12th, Lordship. Much obliged, Lordship.
Obliged.
Much obliged.
Your Lordship.
Where is the order? If you order,
My lord, there's two orders, my lord. Firstly, Lordship may kindly see page 40. Is the order,
60.
uh,
Which order you are agreed?
my lord, the order, the final order passed by the in appellate court, my lord, page 61.
Yes. 61.
Yes, Lordship. 61 onwards, my lord. 62.
Operative person.
Lordship will find. Question, my lord. My lord, it will be page 78, my lord.
78.
From the factual background of the case in hand. Para 24. Lordship got it.
Heard Mr.
G. Uddin, Lordship.
G. Uddin,
Yes.
learned counsel for the petitioner. By filing this revision petition, the petitioner has put to challenge the order dated 30/07/2024, whereby the appeal, miscellaneous appeal case number 21 of 2022, by which the order of injunction
Yes.
passed by the Chief Judicial Magistrate, Civil Judge Junior Division,
Yes, my lord.
dated 21/07/2023, has been dismissed by upholding the said order in title suit number 69 of 2022. Issue notice returnable by 6 weeks. The next petitioner to take steps for solution notice upon the respondents by registered post within 2 days. That's all.
But till then, this order may be suspended, my lord.
No, how can be? Injunction is already there. If we suspend this,
My lord, both the court has dismissed my injunction petition now.
Hmm?
Both the court below has dismissed my injunction petition. So that may be suspended. My title suit will go, my lord. My title suit, my lord. But this order may be suspended, my lord,
why?
because already dismissed my injunction
Then
petition.
in that case, it would amount to granting injunction to you.
Some short date will be given.
6 weeks, 4 weeks. Interim prayer shall be considered on the after service of notice upon the respondent.
Oblige, Your
May please, Your Lordship.
Yes,
Lordship will find the impugned judgment and order at page 59.
yes.
That by which my appeal has been dismissed, my lord, and the order of injunction has been upheld, my lord. That operative portion, lordship will find page 70, para 12, my lord.
70.
My lord.
Yes.
That my appeal, my lord, has been dismissed, and the order of injunction passed by the trial court, my lord, has been my lord.
Injunction against you.
Yes, my lord.
So, this revision petition is directed against the order dated 31/07/2024
My lord.
passed by the London Civil Judge Senior Division in miscellaneous appeal number 04 of 2021, whether the order dated 14/09/2021 passed by the London Municipal number 1, Nalbari, in miscellaneous within Wicket Cross case number 11 of 2021 is affirmed hereby dismissing the appeal will miss appeal number 04 of 2020. Issue notice to the respondent by returning by 4 weeks. Petitioners to take the steps for submission and suspension. Then,
My lord, in the my lord, I also, my lord, notice may be issued, my lord. I have
this after 4 weeks. IA is for what?
first day.
Same hard science, sir. You just said all of them. Hard science. Both, huh? Earlier was hard science. IA also issue notice. IA for stay of the
Impugned
order
judgment.
dated.
Impugned judgment and order.
Impugned judgment order dated
31/7.
31.
31/7.
31/07/2024. Past inside. You should notice returning you to take his steps. This is in IA.
Okay.
In this case, my lord, our prayer is very simple and very little.
Appeal doesn't lie.
I'm sorry, ma'am.
Appeal doesn't lie or what?
Appeal doesn't lie. There, because I am before your lordship against the order of a miss case,
Huh.
not the original judgment of the suit, my lord.
Hmm.
Because in this case, my lord, suit was filed, suit was decreed in our favor.
Yes.
Subsequently, title appeal was filed by the defendants.
There's a fresh trial.
Yes, that, my lord, for first trial. Subsequently, my lord, they approached before the London High Court, my lord, for second appeal, which was also dismissed and directed to go for that trial court. Then we approached before the trial court. Subsequently, my lord, the secretary of the Masjid committee was
No, why,
removed.
if it is dismissed, why, how there can be a direction for de novo trial?
We are not seeking de novo trial.
Hmm.
We are seeking just only because one mistake was committed at the time of filing of the suit. In that time, my lord, our land was shown
It's okay, not that. Why revision petition?
No, my lord. We are seeking for amendment of the plan.
So that has been rejected.
That has been rejected.
Then appeal doesn't lie.
Appeal doesn't lie.
Appeal lies. This is rejected by whom?
Rejected by the London Municipal.
Yes, that appeal lies.
But however, my lord, it is rejected in this case, my lord, for amendment petition.
All right.
Not the original suit, my lord. Not the original suit.
Your Lordship, they have come against the order that is in miss case. That is page number 82.
82.
Yes, it is written in the lower part, Your Lordship. The learned counsel, Lordship got it.
Yes.
The learned
So that the
counsel for the
was
opposite party
by the
defendant stated that the observation as stated above was made in the year 1988. The opposite party also submitted that the petitioner has come out with the instant amendment petition after a lapse of 40 years at the stage of argument, and the same is not maintainable at this stage, Your Lordship. I heard the learned counsel of both the sides peruse the case record. On perusal of the case record, it appears that the instant petition was filed after the argument. Further, the petitioner got ample opportunities to submit the amendment petition, but in spite of the opportunity, the petitioner failed to submit the same within due time as prescribed under the law. Considering the facts and circumstances of this court case, this court deems it fit to reject the petition as the same is not maintainable at this stage. The instant miss case number 607 of 2023 is disposed of accordingly.
What about maintainability? Appeal lies against this order or what?
Appeal.
And my lord, the matter may be fixed on next week, my lord. By this time, we will come with papers with maintainability. Otherwise, my lord,
Satisfy us why it should be under 151.
my lord, 1 week time may be granted. I will come. It matter may be fixed on next week, my lord. On the second week of November.
Having faced with the maintainability of the present revision petition, the Mr.
H.R. Chaudhary.
learned counsel for the petitioner pressed for a week's time to argue on this maintainability.
I am Miss K. Fukan.
MS so
K. Fukan.
K. Pukan,
Yes.
learned counsel for
Government
the
advocate. Government advocate.
Government estate council is present.
Respondent number 1 and 2.
Prayer of the petitioner accepted. Let this matter be listed after a week.
My lord, till date, my lord, my
What
No,
till
no.
date?
till date, my lord, that
You
improved.
argue that will
Obliged.
decide today.
Obliged.
May I please, Lordship?
Yes,
Lordship, matter is regarding appointment on compassionate ground.
yes.
Yes, here, Lordship may come to page number 25, Annexure 8.
Yes.
Where it was submitted that petitioner is an eligible candidate for the appointment of compassionate ground.
Page 28. Eligibility to get a ground holder.
25.
Page 25 to say.
25.
25.
Yes.
Yes, and in the second para of the page number 25, here another candidate was there, but her application was returned back due to non-fill-up of some few columns, which was required for the appointment. And after that, she also refused for her appointment due to some matrimonial ground. And parallelly, the petitioner is eligible after that, Lordship.
So,
Lordship, we have filed our response, Lordship. Though his petitioner is eligible, but there should be only 5% vacancy should be filled up for compassionate appointment.
page 25, you have recommended her name.
Yes, Lordship, but we have to see overall vacancy, Lordship. If somebody is eligible also, then also we have to see the vacancy position, Lordship. Only 5% is reserved for the compassionate appointment. We have
This
filed
is your district agriculture officer, page 25.
Lordship, that is to place before the DLC and SLC, Lordship. Kindly see our affidavit in opposition, page 2, para 4. That the deponent says that the petitioner again applied for compassionate ground next time to the DSC Sirang. Accordingly, DSC Sirang arranged DLSC meeting on 5/12/16 under the chairmanship of the Principal Secretary BTC Kokrajhar. As per government norms, 5% of the total vacant posts should be selected against compassionate ground. Further, the deponent states that as there are two numbers of posts lying vacant under the establishment of the DAO Sirang, and there are 3 numbers of application received by the DAO Sirang, no appointment under compassionate ground was made as per decision of the committee. Lordship, if 20 seat is vacant, then 1 compassionate appointment can be given, Lordship. Here only 2 posts, Lordship, and
But
applicants are 3, Lordship.
Lordship, according
Applicants are 3. There is only 2 posts. If there is 20 posts, then 1 post is for compassionate appointment.
But why page 25? Who has done this?
Only forwarding, Lordship, this is. Later on, we have to see the total vacancy position. If before coming to the zone of consideration, he must be eligible.
But
Otherwise, she is eligible. And while considering the vacancy position, seeing the vacancy position, so her application could not consider, Lordship. Only 2 posts.
Where you have not considered?
Page, our affidavit was stated paragraph 4, Lordship.
It's okay that I've seen.
Yes,
By
Lordship.
which order you have rejected her case?
A copy of the minutes of the DLC meeting annexed, Lordship. Number 1, District Agriculture Department, Chirang. In the office of the District Agriculture, page, Lordship, running page I have not given, Lordship.
This is forwarded by the District Agriculture Officer, page 25. And DLC has considered her case.
Yes, Lordship. Page annexer A2, Lordship. Annexer
Page
A2
number
of our
5,
affidavit. Our affidavit, Lordship.
respondent affidavit, Lordship.
There are
In the
4
para
applicants
1,
for
there also they have said that petitioner is eligible, Lordship.
1 vacancy may be reserved for company. There are 4 applicants for this. There is no
Compassionate appointment is not matter of right, Lordship.
eligible as per rule. No, you see,
Lordship,
as per,
Lordship,
just wait. As per page 25, there were 3 applicants. And you have recommended initially for 1 MS Meenakshi Burman.
Lordship.
Somehow she is found to be not eligible or whatever the reason. Therefore, her case was recommended. So this is, it shows that the Meenakshi Burman was considered.
Kindly see our minutes as per
and
norms of
Lordship,
the
there
compassionate
is
ground.
one thing,
The selection should be made 5% of the total vacant
It's
post.
all right, madam. This is your own decision. You cannot have a different, by way of explanation in the affidavit, how can you have the contradictory statement? Page 25 says that 3 persons were there, including 1 Meenakshi Burman, right?
yes.
1 Meenakshi Burman. You read this, page 25, along with your 3 Srimati Meenakshi Burman, so-and-so, spell comes so-and-so, has been considered eligible candidates for appointment. Accordingly, committee unanimously recommended the name of Srimati Meenakshi Burman, as only 1 vacancy has been reserved for appointment on so-and-so. Further, so-and-so, through which the appointment Sri Meenakshi Burman has been returned back due to non-fill-up of so-and-so. And in spite of several years, she has not submitted so-and-so, suggested her youngest is so-and-so Burman for appointment of compassionate interview following. In view of the above, the undersigned have suggested to reconsider the name of Srimati Deepa Ghosh
Lordship, I
following
shall,
letter refusal by Srimati Meenakshi Burman and suggested by her youngest is so-and-so for appointment compassionate ground. So your annexure, page 48, Annexure A2 was recommended for Meenakshi.
Meenakshi Lordship. If she is not a joint lordship, that post might be filled up by some other person lordship. Lordship,
You
let
have
me
said
satisfy
so.
on the
Your
next step.
director had said so
Please, the matter
clearly.
day after tomorrow, lordship, I shall satisfy lordship.
Lordship, one
Not
more thing.
satisfied. You have
Lordship,
to-
one more thing I want to add.
I'm satisfied that
No,
her
lordship,
case
no,
has
no,
to
no.
be
This
considered.
will open the floodgate, lordship, because this is very old case and lordship.
No, this will not open.
No,
This
no,
is a
lordship.
case
She is
where we
not-
can direct you to consider on your
No,
own
lordship, no.
documents.
2 times her application has been considered. Kindly, lordship.
I'm on your affidavit only.
I am in my affidavit. I am saying only two vacant posts.
Annexure A2.
Only two.
Annexure A2, what does it say? This is of when it was considered 11/31, 11/3/2011 and 16/11/13 thereafter.
5/12/16 also. This is 5/12/16 lordship OM. Lordship. This is DLC 5/12/16 lordship.
Which one?
Annexure A2 lordship.
Just read the Annexure A2. 1. District Agriculture
In the
Department.
official
Chira.
decision, there are 6 vacancies in grade 4. 1 vacancy may be reserved for competitive ground. There are 4 applicants for the post. There is no vacancy in grade 4. Sri Himanshu Roy. So he is not eligible as per clause 43 of the Honorable High Court's direction. Judgment and order dated 2/7/10 under WPC number 29329. Sri Tapas Kumar Nath applied on 27/1/11, but his father expired on demand, so he is also not eligible for honorable one. Srimati Deepa Ghosh and Srimati Meenakshi Burman are eligible candidates. The committee unanimously recommended name of Meenakshi Burman to the office of the DAO Sirang for necessary action.
Yes, this is
recommendation.
DLC recommendation of 25
Recommendation.
to 2011, right?
Yes, lordship.
Then
But
read page 25, which is of 2013.
hereafter, lordship, normally after DLC's SLC will consider lordship.
When
They-
is the SLC is considered? That is the problem.
lordship. Let it be on day after tomorrow, lordship. I shall satisfy lordship.
Will dispose day after
Day after
tomorrow.
tomorrow, lordship.
Lordship, one more thing, according to office
Madam,
memorandum
keep
of,
it yourself. We are
Day after
hearing you again tomorrow, day after tomorrow.
but one more thing.
Don't make her more wise.
Deploy.
And MS so learn counsel for the petition. And also, please come, Miss MS
RB Bora, lordship.
RB Bora, London State Council.
Standing
Press
also
press
DPC.
for and is granted a day's time to clarify on the clarify the issue with regard to the recommendation of the DLC and SLC.
Yeah.
Particularly the annexure. What is that annexure?
Annexure 8, Lordship,
Page 25.
page 25.
Annexure 8, Annexure 8, within brackets, at page 25, and Annexure A2 at page
Page,
40, 48. 48. Annexure A2 is 48.
Running page
Annexed
of
by
the
the respondents. List on 3030 10/2020.
Marvelous.
Which level?
May it
Yes,
please your
madam.
Lordship. Lordship, matter pertains to non-consideration of promotions to the petitioners, as the petitioners are visually challenged persons. As on the last occasion, where the other side have to file their affidavit stating that
Yes,
on which ground
To
they
bring
have
on
been.
records, the instruction, my lord, I have already prepared, my lord. I am sending the letter today. My lord, list after.
Press for 1 week.
2 weeks time, my lord.
2 weeks time.
I'm sending the
File
letter.
affidavit.
Lordship, a date may be fixed.
As affidavit, as he has already prepared and sent it for vetting. The affidavit. This is the 2 weeks.
Obliged, my lord.
In this case, my lord, in the earlier occasion, my lord, the respondent taking time, my lord, to file affidavit.
Yes.
No affidavit has been filed, my lord. Affidavit is required, my lord. It is the fourth time litigation, my lord, against the dismissal.
Lordship, we had to retrieve certain records because this is an old case and only
Last
listed
order.
4 times, Lordship. We'll file it in 1 week, Lordship.
It is made clear this will be the last chance granted to responsible evidence, telling which cost will be imposed.
In 1 week, Lordship.
We are imposing a cost of symbolic cost of rupees 5,000.
Just as last accommodation, Lordship.
No, last was already given.
It was only listed 4 times, Lordship, the case, even though it is an old one. So, Lordship, we had to retrieve certain records.
Well, what to do?
We'll file it in 1 week.
Last order in your presence, this was recorded. What do you say?
Affidavit is required, my lord. That's my lord. That may be fixed, my lord.
Although this court has granted the respondents a last chance for filing affidavit, telling which appropriate cost will be imposed. Mr.
Care Padgiri.
Care
Padgiri.
Padgiri, in his usual fairness, has submitted that since the affidavit would be required, a cost may not be informed. Mr. I. Bhattacharya, then counsel, assures that he will file the affidavit within 2 weeks. Considering that let this matter be listed after 2 weeks, so as to the respondents to file their response.
All right.
Wait, Lordship. Lordship, I'm sorry, Lordship. With regard to item number 52 and 53, Lordship, this has been mentioned, Lordship, without informing me, Lordship. Yeah.
Okay.
Its urgency is that, Lordship, if this revision petition is already dismissed by the side. There is a law in a court order. I have seen this.
Dismissed?
Yes, because they have neither taken steps, any step, 6 years. 2018 it has been filed, and up to 6 years, several orders is there.
Who has mentioned it?
Lordship says, yes, but I have seen that appellant. There is no.
You are for?
I am for appellant, Lordship. The respondent side, yes,
Call him, we'll take it up.
Lordship.
Item 52 and 53.
53, Lordship. At 2, Lordship, I will try to who will mention it.
Not at to any time.
Lordship, obliged.
Its own turn.
Obliged.
You inform him, huh? You inform.
Lordship. Will try.
In the Malot's matter, we have filed affidavit regarding Malot volunteer service to the district legal service authorities.
Yes.
In spite of the court's order, the petitioner is not appearing on behalf of the advocate is not appearing on behalf of the petitioner. So I think they don't have the interest for the voluntary service. In 2017, matter may be dismissed for non-prosecution, Malot. Because they are not interested.
Yes, my lord. I'm for.
He also supporting us.
Number 4. That is
Who is respondent number 4?
Respondent hoise. Come to this. Yes, Malot. I have seen Malot. I have seen from the affidavits, Malot, they are volunteer service and they were also not duly selected.
Paralegal volunteers.
Yes, volunteer. Their function is normally to write a FIR to the poor litigants to inform the police that there may
Who
be
is
case.
triple S per month?
Triple Burma is not there. SC Burakwa is not present. I have seen the joint register judicial report, my lord. on 3/4/2019. This report says, as the case record is the civil rule pending section, the matter could not be checked out. Some due clues were found out from the computer which are being sent here with the foreign information. From the said clues papers, it has been learned that the matter was listed on 1/4/2019, and on the same date, an order was also passed directing the registry to list the again on 8/4/19 by showing the names of the learned counsel for the both the parties. As per the direction of the approach order, it may be assumed that the respondent side has not been representing the matter. The same was informed to the CA by yesterday itself, directing him. These are the reports of the Joint Registrar of High Courts, madam. They are not interested, I think, the petitioner, madam. The old matter, my lord. By resolution dated 29 May 2017, my lord, their services were discontinued. They are there as a volunteer service.
Non-appears for the petitioners on hold. Next one. It is noticed that on the last occasion also, on 02/09/2024, it is recorded that Mr. A.C. Burma, then counsel, is no longer engaged, and some other then counsel, namely Mr. SSS Burma, has been engaged. Okay. Mr. SS Triple S, the matter pertains to termination of the discontinuation of the services of the petitioner as paralegal volunteers. The petitioners were discontinued as a paralegal volunteers on 29, right order dated 29/05/2017. What is that impugn order?
Resolution, but that is not annexed. Impugns resolution 29 May 2017, my lord. That is not annexed by the petitioner.
By resolution taken by the District Legal Service Authority, Karimganj, Assam. Considering the nature of the issue, nature of the case, nature of the matter involved, it appears that the petitioners are no longer interested in pursuing the matter. Accordingly, this petition is dismissed for non-prosecution.
Any interim order may be vacated, madam. Any interim order.
No, it marks along with all that.
No interim order.
It marks along with
Yes.
Mr. T.C. Sutia, State Council, Additional
Senior Government,
and Mr.
VC Das for response number 4.
Well, this is a very old matter. State has not filed affidavit in spite of the deadline given by lordships.
What about that? Before the whatever the
No, writ appeal is over, my lord. Now writ appeal has been filed by the state, has been dismissed.
Maintainability was
Yes, maintainability has been held in our favor.
Well, after the writ appeal, my instruction is that the state the authorities have decided to approach the Honorable Apex Court. Well, I need some time.
Sir, that cannot be a ground for adjournment.
Well, here, for filing the affidavit in opposition.
It's okay. That may be a ground if he agrees.
No, my lord.
If the petitioner
No,
agrees, we
filing of an SLP is their prerogative. We cannot say no. Neither of lordships can say no.
No.
So
No, it is,
If-
it is not a case, my lord, that since 2018, my lord, we are just taking time and all.
No, it's
for filing
okay.
affidavit, my lord.
For filing, contemplating to file an SLP, we're
My
not
lord,
concerned.
Already,
It's
already,
always up to you.
already they have taken steps. But
Unless you file and obtain an interim order, you cannot. Even if
that is one part. That is one part.
nowadays it says, Honorable Supreme Court has said, even if it is referred to the larger banks,
Then also
we cannot
the law which
hold-
is referred will continue to hold the
yes,
field.
we cannot hold it back.
That is.
We have experience personally.
That is
This court has personally experienced.
My lord, that's true. That's true. My lord, what I would like to pray, my lord, Lordship may give us 3 weeks time. My lord. Let them, Lordship, within for filing the affidavit in the matter.
No, it's
Lord,
of,
otherwise-
see, the issue is of 2016. I
Yes.
suppose. Nomination of the IAS.
Lordship.
Milord, without amending the division bench has recorded a finding, Milord, copy to us.
Yes, yes, I've seen it.
Yes. Without amendment of the rules, my lord, they do the equivalence later on, make the selection earlier to it. What more is required?
You have
Just to pick up officers of their choice?
Made up your the lacunas in later point of time.
But that is
anyway.
That is the
My
other
lord,
point
my
of
humble
merit,
submission
my
is, my
lord.
lord,
That is the
Lordship will
point of
fix the
merit,
matter for hearing in the first week of November. Give a date, my lord. Let them do whatever they like. If they file their affidavit
First
is
week
well
of-
and good, or else Lordship will proceed with the hearing.
First week of November will be too short, my lord. That this is the last week of October. 3-4 days holidays are there.
No, these are all questions of law. There is no factual aspect is involved. It's not that we have raised any disputed questions of fact.
Factual aspect has already been recorded.
Yes. It's a question of law.
My lord, an affidavit
Coordinate
given then,
bench
my lord.
as well as before the division bench. We'll grant them 2 weeks.
2 weeks.
Lordship.
Lordship will fix a date after 2 weeks.
Lordship.
But Mr. Kane should learn counsel for the learn senior counsel, assisted by Mr.
T. Chakraborty.
Learn counsel for the petitioners. Mr.
I'm Dina.
Dina, learn senior government advocate.
Lordship.
Press for and is granted 2 weeks time to file
My lord.
affidavit as a last chance.
Lordship.
List this matter after 2 weeks.
Deep blood, Lord. Hello, Lord.
Sir, what is this?
My lord, this is against an order of penalty imposed upon a retired employee. My lord.
Yes.
My lord may come to page number 18, annexure A. This is the charge sheet. It is, may I read, my lord? It is proposed to hold an inquiry against you under Regulation 6 of the United Bank of India Officers Regulation, Discipline and Appeal Regulation 1996. Now, my lord, this is a major penalty proceeding. However, a punishment was imposed which was challenged by the petitioner, and this honorable court set aside the order of penalty. I am drawing your lordship's attention to page 34, the directions given in the earlier round of litigation.
Page
34,
34.
paragraph 13.
Last order of this court.
Yes. In view of the aforesaid discussions, it is evident that the proceeding was conducted in violation of the principles of natural justice and the regulation, as noticed above. Hence, the impugned order imposing penalty is set aside. Since the said order has been interfered on the technical grounds, the disciplinary authority is directed to conduct the disciplinary proceeding de novo by allowing the petitioner to inspect all the relevant documents, including the aforesaid letter dated so and so, to lead evidence in defense, if so required. After inspection of such documents, cross-examine the management witnesses on the new facts introduced on re-examination, and also to give the petitioner an opportunity to explain the circumstances, if any, appearing against him in the evidence provided he does not examine himself in the proceeding. Now, my lord, this is very important. The disciplinary authority thereafter, based on the evidence on record and the report of inquiry officer, as well as the representation, if any, filed by the petitioner, pass necessary order in the proceeding initiated against the petitioner. The entire exercise is directed to be completed within a period of 3 months from the date of appearance of the petitioner before the disciplinary authority. The petitioner will appear on such and such day. Now, my lord, paragraph 15. Before parting, it would be, I would like to observe that the charge sheet was issued to the petitioner on 28/9/99 in respect of the misconduct allegedly done by the petitioner during the year 93 to 95. More than 25 years have elapsed and the petitioner also retired from service on attaining the age of superannuation on such and such date. The disciplinary authority therefore shall, while taking final decision in the proceeding initiated against the petitioner, bear in mind that the sufferings which the petitioner has already undergone because of the pendence of the proceeding for the last 25 years. I hope and trust, in view of above, the disciplinary authority would not impose major penalty having regard to the nature of the allegations leveled against him in the charge sheet dated so and so, more so when there is no allegation of misappropriation of any bank money. Now, my lord, this order was challenged before the division bench and the division bench has dismissed the appeal. So, from this order, what appears, the direction was to go for a de novo inquiry, giving him all opportunity of defense, including cross-examining the witnesses and filing representation. And thereafter, on the basis of the evidence on inquiry, evidence available on the materials of inquiry, a final decision should be taken. Now, Lordship will come to the order of the appellate division bench, my lord, which your Lordship will find at page 38. The last, my lord, paragraph page 40. After hearing the learned counsel for the appellant, we find ourselves in complete agreement with the view taken by the learned single judge. We therefore find no ground to interfere with the impugned order.
Yes.
Now, after that, Lordship may come to page 41, annexure.
Yes.
This has reference to your personal appearance before JM so-and-so, the disciplinary authority on such and such in terms of the order of the Honorable High Court. Subsequently, the bank preferred an appeal so-and-so before the Honorable High Court against the aforesaid order dated so-and-so of the learned single judge. The appeal of the has been disposed of by judgment and order dated so-and-so, so-and-so, so-and-so. In view of above development and having regard to the direction of the Honorable Court by the order, aforesaid order, the competent authority of the bank has decided to conduct the de novo disciplinary proceeding against you in terms of bank letter dated so-and-so, that is the charge sheet.
Yes.
And he was given an opportunity to file his reply. Thereafter, my lord, the inquiry did not take place and then the order of penalty was issued, which your lordship will find at page 43.
This is the order. There
This-
is no inquiry.
No inquiry.
No de novo.
No de novo inquiry.
Only you were given a
Letter,
chance to file a
written statement,
written statement. That's all.
in respect of the charge sheet which was drawn in the year 99 and that too under a major penalty procedure.
Yes, sir.
Now, my lord,
My lord, I will take your lordships once again to the order passed by the learned single judge at page 35, paragraph 15, my lord. Before parting, I would like to observe that the charge sheet was issued to the petitioner on 28/9/1999 in respect of the misconduct allegedly done by the petitioner during the year so-and-so. More than 25 years have elapsed, and the petitioner also retired from service on attaining the age of superannuation on so-and-so. The disciplinary authority therefore shall, while taking final decision in the proceeding initiated against the petitioner, bear in mind the sufferings which the petitioner has already undergone because of the pendency of the proceedings for the last about 25 years. I hope and trust, I'll, my lord, request your lordship to see this line, my lord. I hope and trust that in view of the above, the disciplinary authority would not impose major penalty. My lord, I'll take your lordship to that. What is minor penalty, what is major penalty? Having regard to the nature of allegation leveled against the petitioner in the charge sheet dated 28/9/1999, more so when there is no allegation of so-and-so. Now, your lordship will find, my lord, if we go for
Sir,
major,
admittedly, there was no de novo trial.
no,
I
no,
mean,
my lord,
inquiry.
I'm right now. I'm taking to your lordship there. If it is a minor penalty, no requirement of going through the, my lord, discipline proceeding and all that. My lord, your lordship may look at the disciplinary and appeal regulation. No. Your lordship may see at page 3, my lord, there's a flag mark already. Penalty is defined.
Minor penalty.
Minor penalty, the following are the penalties which may be imposed on an officer, employee, for acts of misconduct for any other good and sufficient reasons. Minor penalties. Number, we are for on B, by withholding of increment of pay with or without cumulative effect. Then, my lord, I will take your lordships to Regulation 8, which your lordship will find at page 9. Procedure for imposing minor penalties. Lordship got it.
Yes.
Where it is proposed to impose any of the minor penalties specified in clauses A to D of Regulation 4, which your lordship has seen, the officer employee concerned shall be informed in writing of the imputations of lapses against him and given an opportunity to submit his written statement of defense within a specified period not exceeding so and so or such extended periods as may be granted by the disciplinary authority. The defense statement, if any, submitted by the officer employee shall be taken into consideration by the disciplinary authority before passing orders. Number 2, where however the disciplinary authority is satisfied that an inquiry is necessary, it shall follow the procedure for imposing a major penalty. Now, in case of minor penalty, my lord, the requirement of regular inquiry is not needed. So, therefore, your lordship kindly see what is the penalty given by us. Your lordship may see at page 50.
50.
My lord. Paragraph 17. I am of the opinion that the Honorable Court, while disposing the application, has included the above observations, as the Honorable Court being of the opinion that the imposition of minor penalty would serve the purpose of the instant case. I will be failing in my duty if I am not considering the august direction of the Honorable Court while disposing the instant case. The analysis of the above solemn judgment and order dated so and so of the Honorable Guwahati High Court clearly leads to the irresistible conclusion that the Honorable single bench was of the strong opinion that the imposition of minor penalty in the instant case would subserve the interest of justice. In deference to such solemn directions of the Honorable Single Bench of Guwahati High Court in WPC number so and so, the facts and circumstances of the case, and also after applying my mind independently, I hereby modify the earlier order of punishment imposed on you by the erstwhile disciplinary authority, by order dated so and so, by inflicting on you the minor penalty of my lord, can I request your lordship one thing? My lord, can I request my court master to, my lord, switch off the AC line, my lord? I'm having some difficulty. My lord, by inflicting on you the minor penalty of reduction of your basic pay by 3 stages lower in the time scale of pay as applicable on 30th September 1999 without cumulative effect. Your lordship, kindly see the wordings without cumulative effect and not adversely affecting the officer's pension in terms of Regulation 4E. So therefore, the punishment imposed is very, very minor. My lord, in a case, my lord, reported in 2015, the appeals court has said, even, my lord, 5 increment has been stopped without any cumulative effect. That is a minor penalty in terms of the regulation. So therefore, I whatever the charges, if your lordship sees, it is a case where we should fall back to the regular inquiry. But since the observation of this honorable court has said that since 25 years is gone, so therefore we hope and trust that he will impose minor penalty. Now, in case of minor penalty only, my lord, we can give him the very, very little amount of punishment. If we follow, I'll take your lordship to the, my lord, the allegation. These are in only one, there are, I think, 12 charges. He used to give loan to the persons without taking the concurrence from the general manager in most of the charges. And in one case, one person is the employee of the bank and he became the partner of a company. Now, under the regulation, my lord, he cannot give any loan if a employee of the bank is involved in that particular business and trade. Now, even on those circumstances, also he comes under the Conduct Regulation 3, and the punishment can be imposed, and that punishment will come within the purview of major penalty. So, merely because, my lord, this honorable court has said to us that you go for minor penalty. Now, if we impose major, there is a, my lord, the question will be the violation of the court, so that, all that will come. But nonetheless, my lord, we have seen that the charges are very, very serious. But we have gone for the simple, my lord, this minor penalty, and the minor penalty has been imposed. Your lordship has seen is not, there will be no loss, because after 3 years, this increment he will get back. Now, my lord, I will take your lordship to a decision of the appeal court.
Okay, but then since if had there been an inquiry,
My lord.
it may not entail even for minor penalty.
No, the inquiry, if we go for, then it will come, my lord, not minor penalty, major penalty.
If it is not, suppose if in the inquiry, if it is not proved,
Inquiry, my lord,
charges, so it's okay.
no, it is already,
Why inquiry is required?
no, inquiry is over.
No, it has to be
The
proved.
penalty was only, my
No,
lord,
court has directed for de novo trial,
yes.
de novo inquiry. You have on the with an observation that may think of imposing minor penalty.
Yes.
That is after the inquiry only.
No, my lord, then
So according to you, since it provides for if the minor penalty has to be imposed, no inquiry is required as per
yes,
regulation
Well,
8.
regulation
you
4.
have gone for a shortcut method.
And then your lordship kindly see this honorable court, my lord, the disciplinary authority would not impose major penalty. Very, very candidly, his lordship has said. Now, my lord, your lordship kindly see this judgment. This is 2015 Supreme Court 533. I'll take your lordships to paragraph 5 and 11. Paragraph 5, your lordship kindly see. The board entered contest in the suit and explained the position as regards the nature of punishment contending inter alia, that the effect of an award of stoppage of 5 increments without cumulative effect would mean that increments for a period of 5 years would be released altogether at the end of the 5 years, and as such, no illegality and or irregularity has been committed by the board in implementations of its orders. Then your lordship can see paragraph 11. At the very outset, we may clearly state there is no discord or dispute over the exposition of facts. The controversy has arisen with regard to implementation of the order of punishment imposed by the authority on the delinquent employee. The courts below have opined that though it is mentioned in the order of punishment that there is stoppage of 5 increments without cumulative effect, which is a minor punishment, yet the manner of implementation converts it to major punishment. There can be no conceal over the proposition that when a punishment of stoppage of an increment with cumulative effect is imposed, it is a major punishment. In this regard, we may refer with profit to the decision of Kulan Singh versus so-and-so, wherein it has been held that withholding of increments of pay simpliciter without any hedge over it certainly would be a minor punishment, but withholding increment with cumulative effect, the consequences being quite hazardous to the employee, it would come in the compartment of major punishment. Similarly, in this case, is a stoppage of 3 increments with non-cumulative effect. Means after 3 years, he'll get back his entire, whatever was withheld, he'll get it back and it will have no effect on the pension. Now, your lordship can see the now charges, how serious it
Otherwise,
is.
he is not losing anything.
He's not losing anything. My lord, 3 years stoppage, he'll get back after the expiry of 3 years. And it will have no effect on the pensionary benefit. So therefore, it is no punish. In my respectful submission would be
In
no
fact,
punishment.
it's not a punishment as such.
No punishment at all.
It's a symbolic.
Very, very symbolic.
My lord, I'd like to draw your lordship's attention to one aspect.
I
my
have
lord.
not finished.
No, actually,
Don't be, have some patience.
It's okay. I've understood.
No, if your lordship permits me, lordship may have a look at the punishment. My senior colleague has referred the punishment to be a minor punishment by taking a lordship to the provision of 4B. Lordship may have the regulation. It is shown as if it is a stoppage of increment. In fact, not. Lordship may have a look at page 50. What is the punishment under which provision and refer to the rules and what that amounts to. Page 50, Lordship will find that the punishment is imposed under regulation 4E.
So 4E.
And Lordship will see what 4E speaks about. 4E is a major penalty.
Lower grade or post or to a lower stage in a time scale. This is major penalty.
Yes, it is a major penalty.
You just read the penalty. Read the penalty.
Yes, 4E major penalty.
Reduction of your basic pay by 3 stages is lower in the time scale of pay.
Under 4E is a major penalty, my lord. And it is projected.
You read it.
No, major
What
penalty 4E.
from where you are reading?
Lordship will see regulation that 4 penalties A to D are minor penalties, and from E to H it is a major penalty, and the penalty imposed by 4E, it has been wrongly projected as my lord minor penalty. And my lord will see regulation 6. Regulation 6 provides no order imposing any of the major penalties specified in clause E to H of the regulation without any inquiry. 4E penalty under 4E. And 4E is a major penalty. Regulation 6 says no penalty under 4E to H can be imposed without any inquiry.
Lordship can see the language. Inflicting on you the minor
Language
penalty
is different. It is and in terms of regulation 4E. The
Let me say you
disciplinary
say-
authority, the
So
disciplinary
impatient.
authority has invoked the penalty under 4E.
The punishment is given what melody lordship can see. The language is so clear, and he is trying to read something else. By inflicting on you the minor penalty of reduction of your basic pay by 3 stages lower in time scale of pay as applicable on 30th September 1999 without cumulative effect. Now this attracts my lord B, 4B.
Written as 4E.
Written, my lord, that may be some typing mistake, it may be, but what punishment has been given?
It's a reduction of your basic pay by 3 stages lower in time scale of pay.
Yes.
Under 4E.
Or if lower stage in time scale. I think it's major.
It is a major
my lord,
penalty.
your lordship, can you see the language by without cumulative effect?
So see, it's okay. This B, 4B is withholding of increment of pay with or without cumulative
Without
effect.
cumulative effect.
But this is reduction of your basic pay.
No, my lord, your lordship, we come under this 4B.
Reduction in lower scale or post or to a lower stage in a time scale, major penalty.
No, we are not followed, we haven't followed E. This is B, my lord, that is the printing mistake, my lord.
What is the explanation
Your
in the
lordship-
affidavit, my lord?
Your lordship,
There is
can-
no explanation in the affidavit. There is a printing mistake.
Now I am on lax. Why you are? This habit is very bad, my lord.
So much enthusiastic. Try to learn the basic concept of
Not the basic concept,
Then-
my lord, what I am submitting, what is not there in the affidavit
You know,
is
let him,
saying something which
your
is not
lordship,
there in
tell
the
him to
affidavit.
sit. Your running commentary, when you argue, you start your running commentary. This as you learned. You have so many years you have been in this profession, you do not know all these things.
You, this language is something, it's of 4E.
Language, my lord, your lordship, I read
Reduction
again.
to a lower grade or post or to a lower stage in a time scale. You just read page 50 again.
50, yes.
Reduction of your basic pay by these 3 stages lower in the time scale of pay.
Reduction of your basic pay by 3 stages lower in the time scale of pay as applicable on so and so without cumulative effect
Yes.
and not adversely affecting the officer's pension.
Why, if you are on minor penalty,
My lord.
you have clearly said it's minor penalty. Then why you use
My
this?
lord, we have
why,
said
why
it.
don't you use this B, withholding of increment of pay?
No,
If you
this,
if you have imposed the penalty under B, 4B,
my lord.
why the words should be different? It's withholding of increment, but
No.
reduction is in pay E, 4E, which is a major penalty.
For E, my lord, we haven't, this is, my lord, a mistake, my lord, we can file an affidavit
You file an
by
affidavit.
stating
My
that
lord,
it's
if-
a
if-
mistake.
Then we'll decide.
Yes, yes. My lord, we shall do that.
See, language, the decision of the authority is very clear that imposing minor penalty. But the language they have used,
Yes,
the reduction of basic pay, which is as that of major penalty, plus the provisions of 4E. Let them file affidavit.
My
Yes,
lord,
yes,
another
so clarify
aspect, what I'd like to draw your lordship's attention to, paragraph 13.
No, if minor penalty is imposed under 4B, I think.
My lord, then
you should
two question arises.
A major penalty, you have a point. If
My
it's a
lord.
minor penalty as per the regulation, so they are clearly saying that you are imposing a minor penalty. This is correct. But the language appears to be of E, 4E. On that ground, if the learned senior counsel appearing for the respondents,
We shall
coupled
clarify.
with the language used by the authority, imposing minor penalty, let them clarify.
In that case also, my lord, lordship will appreciate two things. If it is a minor penalty, then first question arises whether the direction of the honorable court permitted them to take a decision to go for a minor penalty
Forget
proceeding,
about
and
the
whether
language.
there is
Forget about the language. There may be a wrong cutting of the provisions also.
no, my lord. The direction.
Just wait. Now, if the authority who has imposed a penalty on you is categorically making a statement, submitting that it is a minor penalty under 4B, which is also in conformity with the language, except that italics one.
Yes.
No, and there is a
Then
specific.
why you should impose the decision major penalty?
My lord, apart from the language, there is a specific.
See, it's not just saying. The consequences will follow. Suppose if he says, authority says that this is a minor penalty, it will have a consequences. And then if it is, even if they say that it's minor penalty, but if the consequences is different, if it is as per E, then it will have a different thing.
My lord, what I am.
Since
what
they
I-
have categorically submitted that the minor penalty has been imposed under clause B, 4B, why you insist that this is a
No,
major
it is
penalty?
not written as 4B. They are saying it is that this is the
Sir,
penalty under clause
It may
4E.
be- It may be wrongly quoted. The provision may be wrongly quoted. Supreme Court says that it doesn't have a bearing.
My lord,
Much on
there
it.
are decisions also when the document speaks of itself. If the order,
Wrong quoting of the provision would not make the order
but
bad.
but my lord will see the language. It says reduction of
No,
pay.
certain point I agree with you. The language says, but then we have to read the whole. They have decided to impose a minor penalty. If it is 4E, it's a major penalty. It cannot be. I mean, common sense. It's a common sense. So best way out is, on the basis of there, we'll decide. We'll determine it. Let them file a additional affidavit in view of the submission or the language used in the penalty. Then we'll decide.
And in that case, my lordship will also observe one thing.
If it is a major penalty, right? You have a point. If it is a minor penalty, you may not.
Then, my
So
lord,
let them clarify.
whether converting a major penalty proceeding to a minor penalty is permissible under the rules, because this honorable court, lordship, that is why I am referring your lordship to that relevant paragraph.
Sir, if it's provided, it's provided, it's permissible under the law.
Yes.
In the regulation particularly.
Yes.
Why not?
No, my lord. They have initiated a major penalty procedure, conducted an inquiry, imposed a penalty, which was set aside.
You want that you should be imposed a major penalty?
No.
Then?
My question is whether they have followed the direction of this honorable
That too,
court.
at this stage in your evening of your life. Minor penalty.
My lord, whether they have followed this, and whether the allegations may, whatever serious the allegations may be, whether it has been established. Now, why I am drawing, lordship will see what this honorable court.
Okay, sir. We'll allow him to file the additional affidavit. To
Additional affidavit
stand clear. All
by
right?
the authority who has
Yes.
imposed the penalty, because no other authority can substitute.
We'll
this.
just say the respondents will file an additional affidavit placing on record their stand whether it is a minor penalty under 4E or it's a under 4E. We'll just clarify that.
4B or E.
Because he said it's 4B. Right? Not Mr. S. Chakrabarti, counsel for the petition. And also had Mr. S. Datta, senior counsel, assisted by Mr. M.S.
As Musari.
S. Musari, counsel for the response. After hearing the matter examined. I deem it appropriate to direct the respondents to file an additional affidavit by making the stand clear in view of the penalty imposed on the petitioner as the authority has clearly decided to impose a minor penalty. The minor penalty is prescribed under Rule 4E, under Rule 4A to B, which, according to the senior counsel, the petitioner has been imposed a minor penalty in deference to the observation of this court under regulation. It's a regulation. Regulation 4B. However, on the reading of the language that the minor penalty imposed is to the effect of reduction of basic pay by 3 stages lower in the time scale of pay without cumulative effect and not adversely affecting the officer's pension. Appears to be under Rule 4E, which is major penalty. The respondents, no, please, let the method be listed. After 2 weeks.
Well, a date may be fixed. A date may be fixed.
The respondents will file the additional affidavit on or before next day of this. Give after 2 weeks. Then
Not okay.
it's simple.
But a retired employee can also be never impose a penalty of stoppage of income.
Hard in part.
Well,
Possibly you want major penalty.
That is, it is indicating you want major penalty.
I'll satisfy your lordship.
I'm satisfied already.
That major penalty could not have been imposed. No material to impose any penalty. No material.
He will satisfy your lordship to impose major penalty.
Then in that case, you have to amend your petition. If that is
I'll satisfy your lordship that there is no material to.
In that case, no further.
13, the lordship has kept it as part.
Not further. Will hear it. 13. No further. Huh?
My lord, the petition filed for my lord, because my lord medical reimbursement not given to this petitioner.
Yes.
Lordship, the decision that is being challenged here is by Joint Director of Health Services, Dima Hassan. Their response will be required.
It's a medical reimbursement. Sir, other what provision you are entitled?
My lord, my lord, it's a government employee, my lord. So many decisions.
Sir, government employees are being regulated by certain set of rules and regulations.
Yes.
Under what provision?
Lordship.
Madam,
Lordship, we are
under
newly
what
engaged.
provision the medical reimbursement are being paid?
Lordship, we are the newly engaged counsel in this matter. If some time may be granted to file.
Which for whom?
Lordship, for respondent.
PHE department.
4, 6, 7, and 8. Dima Hassan.
Himasa.
Yes, sir.
Who has to pay? Who has rejected it?
Joint Director Dima Hassan. So that will
The director, which department?
Health Services.
They have to pay.
Yes.
They are
They
the
have
one who has to
requested
pay. Right?
Yes, sir.
Who is medical director? Dima Hasso. You are Dima Hasso?
Yes, sir.
You are
Lordship. I am
appearing for
appearing for
Dima
Dima Hassan.
Yes, sir.
My lord.
Under what provision?
My lord, I have certified. Let my.
You have filed a petition. It's an admission stage. We'll see.
But my lord, I have several judgment of our High Court also.
Forget about the judgment. First, you tell us. This court would like to know.
After one
Under
week, my
what
lord.
regulation, what provision, what office memorandum, anything.
Yes, my lord.
If you don't have a basis,
After 1 week, my lord, I will show it also. After 1 week, my lord.
so where you will get there after 1 week?
My lord, I search for that, my lord. I search for that.
You have not said anything in your petition.
No, I have not enclosed any rule.
Forget about it. You just tell us orally. Under what provision?
That is why, my lord, provisions, my lord, to search, my lord, and to submit, my lord, after 1 week, my lord, I will submit that.
See, these are the petitions where, of course, they want time, but then we cannot afford to keep it pending for so long.
And that's
And
why.
if you are entitled, we'll direct. If you are not entitled, we'll dismiss. That's all.
That's right, my lord, but my lord, I have to, my lord, show your lordship.
At times we makes the cases complicated.
No, my respondent are not saying that I am not entitled. My lord, page 32, kindly see, my lord,
No.
their letter.
Before that, I just wanted to know under what provision you are entitled to medical reimbursement.
Yes, yes. My lord, I will show, my lord, after 1 week.
Yes, which page you are?
Page 32, my lord.
32.
Yes.
Yes. Return of medical reimbursement.
Yes.
Claim of medical reimbursement.
But this was not submitted.
Yes, there is a guideline.
Yes,
My
Your
lord,
Lordship.
Government guidelines.
Yes, sir.
my lord,
Because your case has been rejected on the ground that as per the government guidelines, you are supposed to submit it within 3 months. According
within
to
3
them.
months, and secondly, my lord, impanel hospital.
Yes, these are the guidelines. That's why I'm saying maybe any office memorandum.
My lord, I will
These are very crucial for decision.
on that point, my lord, several judgments are there, my lord. After 1 week, I will satisfy your lordship.
When do you want?
My lord,
When
after
can you
1 week.
get the instruction? Do you get the written instruction?
Yes, Your Lordship. Lordship, after 3 weeks.
After 2 weeks.
My lord, they have not filed but any affidavit.
Lordship, we will file.
You file within
Yes,
2
Your
weeks or not before 2 weeks,
Yes, Your Lordship.
and you also place the guidelines.
Yes.
Heard Mr. Swenson, counsel for the petitioner. On the prayer of Mr. M.S. Swenson, learned counsel for Dima Hasso, that the matter be listed for admission hearing after 2 weeks. The learned counsel for the respondent shall file their affidavit on or before the next date of listing. The learned counsel for the petitioner, Mr.
H1
shall place on record the guidelines, public office memorandum, which regulates the grant of medical reimbursement.
Yes, Your Lordship.
So this is a petition challenging the appointment of the respondent to the post of Gabura in violation of Rule 162A of the executive instruction contained in the Assam Land and Revenue Regulation. So far as the advertisement is concerned, some clauses are there which was not fulfilled by the respondent authorities while appointing the private respondent in the post. But the advertisement says, my lord, the preference should be given to the family members of the Gaugura. I being the grandson of the Gaugura, the earlier Gaugura, I should have been given the preference over and above the private respondent. So far as their contention is concerned, one affidavit has been filed by the respondent authorities saying that I am not the resident of the particular village where the appointment was made, my lord. But I have enclosed the sufficient document and material to show that, my lord, I am a resident of the Guimara village and I am entitled to the post of the Gaugura. But for some unknown reason, private respondent has been appointed in complete violation of Rule 162A of the instruction. I have the advertisement, if I may take your lordship to page 13, read petition number 8160.
All the buildings are completed.
Yes, sir.
Same cause of action, they filed a 2 leave petition.
Not same cause of action. Earlier selection list was issued.
The 16 and 17.
One is for challenging the select list. Afterwards, after I filed the first writ petition, they issued an appointment order. And subsequently, in the subsequent writ petition, I have challenged the appointment order issued in favor of respondent.
First selection, then
select list was published on 28/10/2019. Yes. Thereafter, they made an appointment during pendency of the writ petition.
Yes.
The question of section 11 doesn't arise yet. And even though, my lord, this is a writ proceeding, where, my lord, each and every action should be challenged. Subsequently, in the pendency of the writ petition, first writ petition, they issued an appointment order. In the subsequent writ petition, we have challenged that order.
It's all right. We'll not go into that. We'll go on down.
Yes. Page 13, my lord, is the, if I may take your lordship to writ petition 8338, because this will
8338.
writ petition number 8338.
Yes.
That is 16.
I'm holding that.
Yes. The advertisement your lordship will find at page 18. This is the vernacular version. The translated portion your lordship will find at page 15.
15. Yes.
Well, the minimum qualification, I will start from the minimum qualification of the applicant. The applicant must be a citizen of India. The applicant must not less than 35 years. Then applicant must be fit both mentally and physically. 6 is important. Clause 6. Preference shall be given to the family members of the former Gavura. In this regard, applicant must submit a certificate from the Mojadar. I, along with all these documents, along with a certificate from the concerned Mojadar, submitted my application that I am the grandson of the Gavura, earlier Gavura. So the preference should have been given to us. But interestingly, in the affidavit.
What about your father? Your father was not in Gavura.
No, my lord. His father was a
grandfather.
Family members, my lord. I, being the family member of my grandfather, my lord, I am entitled to the post of Gavura as per 162A. Of course, there is an amendment of 162A. Some clauses has been modified and, my lord, amended. I will come to that later, my lord. Then this recommendation, your lordship will find at page 22. The concerned advertisement was issued. Page 22.
Page 22.
22, my lord.
Yes.
This is, with due respect, it is to state that due to the death of Gavura named late Upen Chandra Das, he was my grandfather, of Palasbari Revenue Circle, under Rampur Moja village, Guimara of lot number 47. The post of the Gavura has been lying vacant. So to fill up the post of Gavura, it is hereby requested to select the grandson of late Upen Chandra Das, namely Sri Kamal Jyoti Das, for the post of Gavura. This was the recommendation.
By whom?
By the secretary, my lord.
What secretary?
Secretary of Palasbari Revenue Circle, Gavura Association.
Recommendation.
And president. This is the recommendation.
Yes, then.
Then the select list your lordship will find at page 33. Yes. Palasbari Revenue Circle. I am concerned with clause 16, serial number 16. Palasbari Revenue Circle, Guimara, Phanindra Chandra Das, who has been selected.
Respondent number.
Yes.
Huh?
Yes. Respondent number 4. Which was challenged in the earlier writ petition. Then the order of appointment, page 36.
Yes. There is no order. Date 3110.
Yes.
3010.
3010.
Yes.
Impugn order relevant portion.
Where it is? Page 36.
Yes, sir. Page 36. 16 to open order selection. This. It is hereby instructed that the newly appointed Gavura shall help the government officer employees as well as the Mojadar in respect of collection of revenues and shall also help the Lat Mandal. This is the impugn order by which the.
Where is your, where is the
That's what my doctor.
The respondent Goimara is not there.
Yes,
It is not in the select list. That I told you. The private respondent name has not been typed in the
Typed out.
NS service.
But in vernacular is there.
Inadvertently, it is Malot.
Correct. You give the type copy.
Vernacular is for lordship serial number 16.
How do you know? This code is
But
handicapped.
But this select list, what I have shown to your lordship, page 16, at CL number 16, my lord. That was he was the person who has been appointed, and there is no denial to that, my lord.
Who has translated this? It's you.
My lord, I take the responsibility, my lord.
What is to be done?
But otherwise, there is no denial that the respondent number, private respondent has not been appointed in the post. There is no denial. Had there been a denial, the question would have been different. But
Yes,
so far as the select list is concerned, I have shown.
Just show me that vernacular. Where is it?
16, my lord. Serial number 16.
Page
38.
1, 2, 3, 4, 5, 6. 16, 7. Which one?
16, my lord. Polasbari Rajo, sir. Gui Mara.
16.
16, my lord. And my contention is that, my lord, there is a complete violation of the mandate of the law. 162 A says, my lord, the preference should be given and he should be the resident of the village. But so far as the affidavit of opposition filed by the respondent, there is a statement that he is not the resident of the village.
So,
which is not correct, my lord, because so far as the certificate is concerned, recommendation is concerned, and so far as, my lord, his grandfather is concerned, who was also a Gavura, my lord, of Guimara, after whose, my lord, death.
That disputed question, how do we
So he has not filed a reply, Lordship.
determine? How do we determine? You are saying that I am from this village. He said that they are not the village. How do we determine?
My lord, there is no denial that the grandfather of the
Denial
petitioner.
is something different. Suppose now I am originally from Baya village in West Siang district. I am staying in Naharlagun now. So suppose it has to be appointed, which would be there? You might have shifted also.
Well, when
Maybe the grandfather was in the village.
Yes.
Father might have shifted also. You might have also shifted also.
Till the death of my grandfather, he was residing there. After his death, my lord, immediately
Problem
after,
is how do we determine
well,
this?
after his death, this advertisement was issued.
Sir,
to fill
how
up the
do we
vacancy.
determine this? Whether you are from this village or not? If they are saying that the authorities is saying that if you are not from that village, how do we adjudicate that? How do we say that you are from that village? Sitting in the writ court.
Even then, lordship in our division bench process.
Violation.
That's correct.
Preference. It's a preference. It's a preference.
Preference, Lordship.
Yes.
Only preference.
You have to-
Only preference, Lordship.
Preference. But the other basic thing is the person should be from the village only, particular village. If you are not that from that village now,
But when the recommendation is made by the Mojadar,
recommendation, what is it? Is it permissible under the law that you should be recommended?
in the advertisement, it is there in the 162A. There is a
A
clause.
recommendation has to be given
Yes.
by the president and the secretary.
Yes.
Is it?
Yes.
President secretary, there is no mallet there.
Well, had I not been the resident of the particular village, I would not have.
Violation of what? Which
162A.
Rule 162A
A.
of what?
Executive instructions.
I have been annexed in my affidavit also.
Well, it has been amended. I will come to that, my lord. Well, let me complete.
affidavit.
Let me complete my own part, my lord. If I have no case, my lord, your lordship will dismiss my case, my lord.
Obviously.
Yes.
Obviously.
There is
you
no-
don't have
I
to
also
tell
want
that.
to point out that modification which was published on 10/4/2020.
Okay, sir, I'll hear you. Yes.
Well, this 162A of the executive instruction land revenue regulation.
Just read it. What does it say?
Gavuras shall be appointed, suspended, and dismissed in the case of Sadar subdivision, deputy commissioner or the subdivision officer in case of outlying subdivisions by the subdivisional officers. If, however, the post of, my lord, this is not, we are not concerned about this. We are concerned on the next part. In the matter of appointment of a Gavura, the following factors shall be taken into consideration: the claims of the family of the Gavura, the views, the Mojadar, the suitability of the person for the post. Well, these are the considerations which should have been taken by the responding authorities while making appointment. Of course, there is an amendment of this 162A provision in the year 2019. In the amendment executive instruction 2, my lord. In the principal executive instruction in executive instruction number 162A, after the existing clause 2, the following new clauses 2A, 2B, 2C, and 2D shall be inserted. After the existing clause 2, 2A, the deputy commissioner, principal secretaries, or autonomous council area shall remove any Gavura if she is having 2 or more than 2 children from a single or multiple partners prior to the date of coming into force of this notification, so and so. If any Gavura divorces his wife and subsequently is separated while gives birth to a third child without remarrying with another person within a period of 9 months from the date of separation, he shall be removed from the post of Gavura by the concerned deputy commissioner principal. Notwithstanding anything contained in clauses 2 and 2B above, if the child are triplets, then the Gavura shall not be removed from his or post.
We are not concerned.
We are not concerned. But to the I am just reading out this amendment that has been brought, which my learned friend was submitting. There is an amendment to the executive instruction by notification of 2019.
2018.
2018, another rule is there.
I have annexed that 2018.
But 2018 says this 10th April 2018. Substitution of 2 executive instruction number 160. There the appointment of Gavura is there. Government of Assam may appoint Gavura for any or more revenue villages in the whole of the state. Your lordship is having the copy, my lord.
I have annexed in my affidavit. The affidavit filed by the respondent number 1.
What is the relevancy?
Well, the appointment regarding appointment of Gavura, some amendment has been brought, my lord, in the year 2018.
So what are those amendments?
Well, this government of Assam may appoint Gavura for 1 or more revenue villages in the whole of the state, as per the norms laid down and notified by it in this regard. Well, in the principal executive instruction, the minimum qualification, my lord, 162(1), he should be a citizen of India and a permanent resident of the area in respect of which he seeks appointment. She should be of minimum 35 years of age, should be minimum. 10 pass from a board institution recognized by the state government. She should be physically fit and have sound mind. She should not have been declared as an insolvent or defaulter preference shall be given to the family members of the Gauburas and the views of the Gaubura Mojadar shall be taken into consideration. So far as this clause is concerned, there is no amendment. Even in the 2018 notification also. And others are not same. He should be a government employee, he should have landed property. My only ground, my lord, to challenge the appointment and the selection of the respondent, private respondent is, my lord, non-observance of this mandatory instruction of 162A. Even after the amendment, this
162A of what? Preference.
of the act, yes.
Preference.
Yes.
Preference to the family members.
Yes.
That's all. That's all.
And in fact, there are
decisions,
my lord. Yes.
So as
that's all, my lord.
What is the decision?
Well, decision I have quoted in my read petition 2000.
What does it say?
1985 3 SCC 267 para 9.
Saying what? On the preference?
Not on the preference, my lord. The thing which should be done in a particular manner should be done in that particular manner only, my lord. And so far as the preference is concerned, my lord, it cannot be swayed away saying, my lord, that this is there, but we are not going to observe this, my lord. We are not going to, but there is no finding to that effect in the selection list or in the appointment. That though he belongs to a Gaubura's family and there is a recommendation being made by the Mojadar and the president secretary, but for some unknown reason, but for this reason, we are not going to appoint him.
For the reason that you are not from resident of that village. There's a reason, known reasons.
But in my humble submission, when this, my lord, interview letter was issued to me, when I applied.
You should rely on judgment of the Supreme Court on the preference.
Yes.
Not that particular act and all.
But so far as my residency proof is concerned, had I not been the resident of the particular area, my authority should not have issued interview letter to me, my lord, because in the filling up form, I have given all the documents. On the basis of that document only, my lord, I received the interview letter. Later on, they cannot come and say, no, he is not the resident of the...
You have appeared for the interview.
Yes, I have appeared.
Therefore, the real issue, the judgment you should rely on the preference.
But on the preference is, my lord,
what is preference? It has been long line of decisions of the Supreme Court.
So far as resident is concerned,
you want this court to do your homework. You are only on preference, being a family member.
Yes.
You should place some judgment on preference. Or is it goes against you?
No, my lord, it doesn't. If I may read, my lord.
Preference? Perhaps it goes against you.
Well,
that
preference,
could be the reason you are not placing the judgment.
He has obtained a lesser mark, lordship. Then the
well,
private
let them
respondent.
complete first, then my lord, I will reply them, my lord. Every time, my lord, I am submit, they jump up something from nowhere. It doesn't. Then sometime maybe given, then I will bring this.
Anything you want to say?
No. My lord, there is a division bench judgment. The preference cannot, my lord, that the Gaumbura post is not the heritage. Division bench says that, but they cannot claim that my father or my grandfather or my family
why
member.
You provided in your
Lordship, may kindly see the
saying, why you have provided that the preference be given to the family members?
No, my lord, we will not give them the preference. Preference will
You have
be
provided
given.
in
No,
the
but preference,
executive
when the
instruction.
preference will be given, when there is an equal mark, then preference will be given. Otherwise, my lord, no.
My lord, there is a judgment of the Supreme Court in the
my lord,
Mohinder Singh Gill, my lord, which is not there in the order, my lord, that cannot be improved by an affidavit opposition.
You recharge on the question of preference.
Yes, I will do.
Some judgment, that's all.
Yes. And so far as their contention is concerned, then I am not a resident, preference cannot be given. This cannot be, my lord, improved by an affidavit opposition in terms of the Supreme Court judgment, Mohinder Singh Gill. They cannot come and say that, no, for this reason, I am not given the preference to the petitioner.
That makes remains that if you are not a resident of that area, how can you...
Well, if I am not the resident of that, they should not have issued interview letter to me. Well, I received the call letters from the respondent authorities themselves.
We'll see.
Yes. Well, the records may be called for, then everything will be clear.
Mr.
Chakraborty.
Respondent,
Number 3, Lordship.
who is respondent number 3?
3, Lordship. Deputy Commissioner. Deputy Commissioner file
Appointing authority.
appointing authority.
You have 4 respondent number
One
4.
1 and 2.
1 and 2. Who is for respondent number 4?
For my lord, private
Private
respondent.
respondent.
Yes, inform. Has been served.
Yes,
Notice.
by Dusty we have served.
Nobody is representing it.
No, I have not seen it.
No. Notice is served. Tomorrow. What happened? Huh? Just a method. Hearing remains. Hearing remains conclusive. List for further hearing on 29, 1/0/2020.
My lord, I'm My lord, I am appearing for item number 18 and 19. My senior is out of station. The matter may be taken up.
No, we're disposing it of.
I have submitted one leave application, my lord.
Huh?
Advocate leave application also I have.
What is the matter?
Matter is they are the employee of the NRC.
It's still going on.
My lord?
NRC is still going on.
No, the termination isn't challenged, there are different categories of employees.
Yes.
In fact, they appear for the
18 and 19.
The helpers, we appear for the junior assistants, and there's another set member who are for the
Next item.
next item. So item number 20,
So
I'm
it's
led
still
by,
going on.
yes, madam. I'm led by Mr. Ken Chaudhary, madam, senior advocate.
Yeah,
In fact, senior
It's
advocate.
still going on.
Yes.
That's what you call it? The
Seniors, both of them are on legs, madam.
No, that process is still on.
Process is still on, and in fact, my lord, pursuant to the latest judgment, the 6A judgment, there's some, my lord, there'll be some modifications in the present, my lord, the state of affairs, my lord.
Yes.
My senior, Mr. Ken Chaudhary, would appraise my lord, my lord.
So
my
how-
friend is praying for time. His
So
senior
your pleadings are completed?
pleadings are complete.
Complete.
Yes.
We'll hear you today. Are you still continuing, all of you?
No, my lord, although there were interim orders in my case, at least item number 20, but that was not complied with. My lord. We're terminated, and even they are terminated. My lord.
When you were terminated?
Tomorrow we get.
Terminated on 9/1/2020.
26/03/21, my lord.
I was terminated on 31/1/2020.
Very good.
So you in your place, some people have been appointed.
No one, my lord. No one. That is the grievance, my lord, because as
So
per
you
the
are
rules-
not, I mean, according to the authorities, you are no longer required.
no longer required. But that is the, my lord, where, because as per the rules, my lord, NRC is a continuous process, my lord. Like the registrar of births and deaths is a continuous process, registration of citizen is also, that's one of the grounds, my lord. That since it's a continuous process, there has to be a permanent office for that, my lord, a department. And we could not have been terminated. And there are other grounds as well, my lord. Well, they take it up, fix it up for hearing, my lord, then dispose of the matters, my lord, all the matters together. Date fixed, my lord.
Heard this learned counsel for the petitioner, and Mr. Mahanta.
Imam.
Learned counsel. This is item number?
I'm for 18 and
Can be
19.
listed together.
Together,
Yes.
my lord.
Item 6.
18 to 22.
18 to 22. And what about you? 18 to 22.
18 and 19, my friend is appearing, my lords. For item number 20, I'm led by Mr. K.N. Chaudhary, my lords. And 21, my friend appears, my lords.
20, 22, 22.
21
Yes. Three of them.
I'm in the
Item 18 to item 18 to 22, right?
22, my lords.
I'm in item number 20, my lord. I'm item number 20, my lord. I am for respond number 1 and 2.
Correspond number 1, item 20,
20.
Writ petition 2831. What about the state?
State is the implementing
the
agency.
party.
It is necessary
Obviously,
party.
they are the one who have appointed you.
Yes.
Yes.
Who has appointed? The state is the authority.
The coordinator
who have
NRC, my
Yes,
lords.
coordinator. State
Huh?
coordinator.
Yes,
State
they were
coordinator.
appearing on the other day.
Sir, who is appearing for the state? Termination of the helper and the, what is that?
NRC, there is a standing also.
You inform him. We are admitting it and this is for hearing.
Maybe they can follow up. I think last order, but there is the direction to file the PDD. They will stand whether NRC is in possession or in force or not. I think. Whether they have file or not, or we don't have the file.
Hearing of fixed course in the meantime.
Good,
quite
good.
well.
That's why I'm asking. It's still, it's continuing.
Yes.
Registration and all.
Not completed yet.
So how you are managing it? This
Exactly, that's the ground, my lord. Because it's a continuous process, my lord.
If you have not engaged some other employees, how you are managing it? You inform the standing council and also you obtain an instruction.
Yes. So let's say my printer matter for hearing. In the meantime, if not filed, they will file a petition. They are going to Lordship, the order is at
Admitted, list for hearing. After
Malad, in item 20, there was an interim order which is operating.
interim order passed
Only in item 20.
interim order passed in writ petition
2831 of 21.
2831 of 21.
Deeply obliging. The date is
After 3 weeks. 3
Item
weeks.
21 and 22 interim order.
Then you write. How many interim orders in the, how many in
18, 19, there's no interim orders
then
operating.
20, 21, 22, huh?
I'll be fixing a date for hearing, Malad.
After 3 weeks.
After 3 weeks.
Give the date.
In this matter, Lordship, I have filed a additional affidavit in opposition on 25th, Lordship. So I have checked the record, Lordship, that that is not in the record.
What is the matter?
Lordship, here the petitioners were appointed under a pilot project, Barn Care Unit, Lordship, in the district of Dhuburi. Along with Lordship, in Assam, under the pilot project, 3 medical colleges were identified for the Barn Care Unit. One is Nagaon, one is Guwahati Medical College, and Dhuburi, Lordship, Dhuburi Civil Hospital, Lordship. And we are appointed by the Hospital Management Authority, secretary by the Deputy Commissioner, as a dresser, Safai Kormi, other responsibilities. And we have been appointed in the year 2014, Lordship. And we have been served up to March 2021 because there is a communication, Lordship, in the 2020, Lordship, that we should, we are directed to discontinue, Lordship. We are directed to discontinue. A communication was made to the hospital authority that we should not work till after March 21. And thereafter that Lordship letter was challenged before the Central Court, and this letter was state, Lordship. And this is not in force. Until then, we are not allowed to work it, and no salaries was paid to us, and not any and not our
You are
service.
no longer in the job now.
Lordship,
You are not working now.
Lordship, we are forced. We are not. We are going to hospital, but we are not. We are not able to sign in the register, Lordship. Forcefully, Lordship.
Since when?
Since after March 2021. And no, Lordship, that
Your
March.
appointment on the basis of MOU,
Yes, Lordship.
on contractual
Yes.
basis.
Lordship, Lordship will find one.
Let us see the appointment order. What is
Yes, Lordship, that will be, Lordship, clarify the case, Lordship. One order, right?
You show us the appointment order, your appointment order.
Yes, yes. I need to Lordship about that. Appointment order, Lordship.
Safai Kamsari.
Yes, selection. Yes, Lordship.
You all are Safai Kamsari.
Yes, Safai Karmas, someone was dresser. Dresser, what boy is there?
How you will be allowed to continue? You have been appointed on contractual basis.
Yes, Lordship, but similar situated person, those who are appointed in the Guwahati Medical College, they are still working.
Who are they?
Under the same MU.
Where are they?
Lordship.
How do we know?
Yes, Lordship, we have information about this, Lordship, and I have, that is why I am submitting before December 4th. They are still working.
What additional affidavit you have filed? On what context?
Lordship, that direction will be given. That is why, Lordship, I am that submission. I am.
Sir, I am not getting any head and tail.
No, Lordship.
Just give me what is that order? What you want to make? What submission you are making? I am not getting any head
Yes,
and tail.
Lordship.
What is that? Let me see.
Yes.
Actually, they are contractual employee, Lordship.
Sir, madam, what affidavit? To what extent? To what extent?
Lordship may take up the
Issue-
matter
Yes, yes.
another day, Lordship.
Not
It's
another day.
under-
I just wanted to know what affidavit you have filed, on what issue, for what you have filed.
Issue is, Lordship, during the pendency of the writ
Lordship,
petition,
before
Lordship,
taking this order, Lordship, can you see the affidavit filed by the Lordship director, Lordship?
no, Lordship, may
Affidavit
kindly
filed by the
see,
director, Lordship. Let me
this-
submit this.
Lordship may kindly see this letter, government letter, Lordship. Which was placed by the council earlier. On the basis of that, court has directed me to obtain instructions.
On the basis of this, you have obtained instructions.
Instructions, and that instructions I have filed an additional affidavit.
Saying
Lordship.
what?
Saying that they are In
You just read the
they,
one paragraph.
now initially they engaged 80 numbers of employees. Now there are only 8 workers are there, and that is in the barn unit of Dhubri, Lordship. The civil barn unit of Dhubri was dismantled, Lordship, as per government notification, Lordship.
This court has stated that the discontinuation order.
Yes, Lordship.
On 26/3/2021.
Yes, Lordship.
Operation is part of the order dated so far as relates to discontinue service of the applicants who are serving in burn units of civil hospital Dhubri.
Yes.
By Kamchari. Effect of this order will be that opposing parties shall not discontinue service of the. Still then you have not been allowed to.
Yes, Lordship. And no salaries were released, Lordship.
But now the department has taken a decision.
Lordship.
Consider all the cases, including your case.
Yes, Lordship. This is my letter, Lordship. I have provided them, and then they are
That
asked to.
notification,
They are asked to
notification
take
what?
instruction, Lordship. Lordship,
Notification only for the Dhubri civil hospital, Lordship.
No.
Yes.
Notification is not for other hospitals.
Lordship, one thing, Lordship. Kindly may I submit?
It's only for Dhubri.
Only for Dhubri.
Yes, Lordship. But
So they are considering.
Now they are. it is
all
there,
fine.
Lordship. Only the contractual posts under Barnini Dhubri are to be discontinued from 31/3/21 as only 8 numbers of contractual staff like driver, dresser and ward boy are working at present, and they will get an opportunity to apply for regular post. So,
Whose letter?
as per that notification, just I have served.
Madam, your discontinuation order has been stayed by this court. Whether you are allowing or not, they are not filing any contempt. There is something different.
I
But not
have
on that.
contempt, Lordship.
Now,
It's pending.
whoever you have been allowed to continue, you have taken a decision that all this, not only this, but other relevant, there are other similar cases were appointed on contractual basis or other issues shall be taken up for the government, for the consideration of the government. That is your decision now. We are not particular or handpicking anyone. They are before this court. There is a stay order of this court.
Lordship, I fix a date, short date, Lordship. I will argue the matter.
That decision, this is of June 2024. What is the next step? You have taken a decision to consider it and then place before the government consideration. You find out where is the status of that decision. Any progress?
Lordship.
Or Mr. Swenson.
Lordship, that affidavit, one copy I have been served. About that, they stated nothing, Lordship. They have filed the affidavit on the basis of these instructions.
Yes.
They stated nothing about this process, Lordship. Can you see the affidavit? I have a copy, Lordship. This happened.
Or Mr. Swenson, learned counsel for the petitioner. MS.
Diora.
Learned standing counsel for health department submits that she has filed an additional affidavit. However, it's not, the same is not placed with the record. Next paragraph. As per the instruction placed on record, it is seen that the Department of Health and Family Welfare Governor Masam has taken a decision on 10/06/2024 to the effect that a policy should be formulated to collectively address the cases of regulation of services and the claim of minimum scale of pay, which shall be placed before the government for decision. Mr. The next one. In view of the above, let the Standing Council MS Learned Standing Council MS D. Bora to place the instruction to obtain instruction the status of the decision as referred to above. List the matter after 3 weeks.
Lordship, they have already filed the affidavit.
Standing Council to place on the court to obtain instruction and place on the court.
No, Lordship, they have already filed, Lordship, on the basis of, they have already filed, Lordship. They have already filed and served a copy, Lordship.
Saying what?
Taking, Lordship, nothing about the state of the regularization.
Therefore, we are directing to place on record the status.
Again, Lordship, they have already submitted one affidavit.
In affidavit, when he is not when nothing is placed on the affidavit, we are asking for the instruction to obtain
There
the
was one
instruction.
observation, Lordship, that the medical college Dhupri Bar unit, Lordship, whether it's still functioning or not, under the same MOU, Lordship. Well, we are not allowed to.
Thank you. Next.
Here are the petitioners.
Yes.
Here the petitioners were nursing assistants serving in the Assam Rifles. After several rounds of litigations which went up to the Honorable Supreme Court also, they were found to be entitled for payment of nursing allowance.
Yes.
At par with the other nursing personnel of the Assam Rifles.
Yes.
Now, while they were being paid such allowance, suddenly, my lord, just prior to filing of this petition, in the year 2019, it was stopped and an office order was issued by the respondents that it will be only paid to those persons who had nursing qualifications. It is at that point of time we came before this honorable court. Because in the earlier round of litigation, it was already held by this honorable court and upheld by the Supreme Court that qualifications will have nothing to do with the allowance. It is the nature of work and duties done by nursing personnel. During the pendency, my lord, that in the Honorable Supreme Court, one batch of persons went and filed a contempt petition because the nursing allowance had been stopped despite dismissal of the SLP. We came before this honorable court. Now I am told, my lord, that they are now started
Yes,
on the pressure of the contempt petition, my lord. They have now started paying everybody the nursing allowance again.
Yes,
but
sir.
my lord, the period from 2019 to my lord September 2024, that arrear part, they have not paid us. If we are entitled to that, my lord, perhaps the petition can be closed, directing the payment of the part which has not been paid by them. That is prayer 3 of my petition, that is request.
Yes, since when?
Let's say, as per this instruction, from the month of September, they started paying the amount, Lordship, but it is
Not the
clear.
arrears.
Area part, Lordship, it is not stated, Lordship.
We were paid till June 2019, and if Lordship has page 17,
June
2019, and if Lordship has page 17 of my petition, my third prayer is
page
17, my lord. Prayer 3. Issue a written nature of minimums directing the respondents to provide nursing allowances which has been due effect from July 2019.
Yes.
Prior to that, I have been paid. Now I am being paid. So this entire matter, this lordship considers that part.
Now,
if they pay me from July 2019 to September 2024, the earlier part, since they are continuing matter, otherwise the petition is infructuous.
so your instruction says that since September,
September
you are paid,
24 lordship.
not before that.
Before
What about
lordship,
that?
it is
I was
not,
being paid before that till June
it
2019.
is not clear
No,
from the
June,
exception
June,
lordship.
July 2019
Lordship.
till September 24.
Or
What have you done?
lordship, yes.
What have you done then?
Lordship, in this aspect, I have to take instruction lordship because I have received this.
No, we'll close that with a direction that if not paid, the from the should also be paid.
Or it may be taken up on Wednesday lordship. In the meantime, I will take instruction lordship. Area part regarding area part lordship.
Area means since you have discontinued to pay
To their lordship.
in this intervening period, now you have decided you will have to pay because they have been paid earlier before July 2019.
Lordship.
Till June 2019, they have been paid.
Lordship.
Now they have decided because of all this
Yes, lordship.
containment and other things. So this period also cannot be, I mean, you cannot deny this period also. We'll say if not paid, they should also be paid from 2019 to till this September.
Yes.
In view of this,
Lordship.
whatever you want to do it, do it. All right. Mr. Majumdar, learned counsel for the petition.
Lordship, if it is taken on Wednesday, lordship, I will, or it may be taken up at
Day after
lordship.
tomorrow.
Lordship, or tomorrow, lordship. I will
Let
take
us not-
instruction regarding
Let
area
us
part,
not put her
lordship.
in the soup.
Lordship.
Then in that case, you may obtain the instruction by 2.
No, lordship, tomorrow, lordship.
Not tomorrow,
Today-
tomorrow so many matters.
Tomorrow or Wednesday, lordship.
Day after tomorrow. We'll close on the
Yes, Lord.
one line order.
Yes.
All right.
Yes.
There's no dispute now, except that period.
Yeah, except that period, lordship.
Because he has paid for also. And also, if you are not paying and if you cannot pay also, we'll have to direct you.
Yes, lord.
Because this petition he has paid.
Yes.
On the prayer, Mr. Armajumdar, on the prayer of next prayer, MS Ardevi, Lana CGC, this matter on 30/10/2024, so as to enable her to obtain instruction as regards the payment of nursing allowance from July 2019 to August 2024.
Please, Lord, the petitioners are working on fixed pay basis. Lord.
Yes.
The Water Resources Department. Lord. One of them is a boatman. The others are Lord, working as sweepers. Lord. So we are basically Lord, seeking the minimum scale, Lord, in minimum scale, Lord, in terms of the open the judgment. Lord.
Now, we were asked to file an additional affidavit.
Saying what?
So they have taken a stand that Lord, we are part-time workers and we are called on need basis. On that Lord, instruction, they were asked to file an addition that was last.
File it.
Yes, Lordship.
Have you filed it?
No, Lordship. We have the instructions, Lordship. Sometime maybe.
What does it say?
Lordship,
Additional affidavit. They filed the affidavit.
They filed the affidavit.
Additional affidavit would like
The affidavit was silent. Therefore, Lord, they sought time to file an addition.
Mr. and counsel for the petitioners. How many petitioners?
4 million.
Yeah, petitioners. Next, Mr.
C. Sharma, Lordship.
C. Sharma, Standing Council.
Yes, Lordship.
For
Water Resources.
Water Resource Development Department. Water Resource Department.
Water
or
Resources Department. Resources Department.
Water Resource Department. First for granted 2 weeks time to file additional affidavit to bring on record the
May I press for date, madam?
This after 2 weeks. 3 weeks in that case.
Madam.
So it's still serving.
Still serving, madam. Still serving.
3 weeks. In that case, 3 weeks. After 3 weeks, you have to Yes, next.
May I please your lordship? Lordship, matter relates to re-engagement of the petitioner who was working as a work charge employee under the DC office Kamrup for long 18 years. Suddenly she was disengaged and thereafter the matter has been under litigation. This is the third round of litigation. Now lordship will kindly have a look at order of this honorable court dated 18 to 15 at page 53. There are certain observations, admitted facts regarding this particular
No,
case.
you filed the reply.
Reply file, they have also filed a reply. Against that, we have filed a reply.
Okay.
Matter can be heard and disposed of today, lordship.
You are still working?
No, lordship.
Which order you are referring
I am
to?
relying upon lordship page 53 order. Page 53.
53.
Page 53, lordship may kindly come. This is all the facts and also the direction and observation of this honorable court, lordship. Page 54 is the relevant portion. Page 53, last line I am reading, lordship. Case of the petitioner is that this is order dated 18 to 2015, single judge. Case of the petitioner is that she was working as data entry operator in the office of Deputy Commissioner Kamrup Metro on contractual basis since the year 1994. However, her contractual engagement was continued without any break. After rendering service as data entry operator for 15 years on the instruction of higher authority, petitioner was shifted to the office of senior sub-register Guwahati in the year 2009. After rendering service there for about 3 years on 7/7/12, she was released from her service with effect from 30/6/2012, along with some other employees working in the office of the senior sub-register Guwahati. Aggrieved petitioner has filed the writ petition. Now, lordship, this honorable court's direction, second last paragraph, it starts with the above contention. Same page. The above contention, their contention has been disputed by the petitioner in her rejoinder affidavit, wherein she has stated that she was engaged in the establishment of the Deputy Commissioner as data entry operator on 19/9/1994 and continued in such capacity till 26/2/2009, when she was shifted to the office of the senior sub-register Kamrup. There she worked as computer operator with effect from 27 to 2009, every day till her release on 7/7/2012. Had she not been shifted, question of her release from service would not have arisen. Learned counsel for the petitioner submits that those persons who are similarly engaged like the petitioner in the year 1994 are still continuing in the office of the Deputy Commissioner Kamrup Metro in the land record branch. Petitioner had no control over her shifting to the office of the senior sub-register, which was done by the Deputy Commissioner. Had she not been shifted, necessity of her disengagement, the direction, lordship, having regard to the above, considering the fact that service of the petitioner was utilized by the Deputy Commissioner Kamrup for more than 15 years. Before shifting her to the office of the senior sub-register, where also she rendered service, the Deputy Commissioner is directed to consider re-engagement. Yes. Now, lordship, in terms of this order, they have passed an order, speaking order. They have wrongly considered me for regularization. However, my case was not for regularization. Against that, I approached the Honorable Single Judge again. Single Judge also on a wrong assumption, lordship, considered my case on the ground of regularization. So that writ petition was dismissed. Against the approach, the division bench. Division bench held that yes, I have a right for re-engagement, not regularization, which was not my prayer. For re-engagement, I relied on an office memorandum 30/10/2001, which is part of this writ petition. I will take your lordship to that also. So division bench directed that my case should be considered for re-engagement in terms of this office memorandum dated 30/10/2001. That your division bench order.
It's okay. Thereafter,
then lordship will then they again pass the speaking order.
Saying what?
That rejection order. Now they say that I do not have 5 years of service. That speaking order, lordship will find it 105. Latest speaking order which I have challenged in this particular writ petition, 6/12/2022, page 105. Page 105.
This is your writ petition.
Yes.
This 155.
Lordship, writ petition 1507.
53. 53 is by you only.
53 is by me.
Okay.
Now, latest rejection order, lordship will see page 105. What is their ground of rejection?
In view of subject letters and do not corroborate your claim of continuous working in the office or in the office of service for a period of 5 years or more. Such your opinion you can consider. Yes. 6/12/2022.
Yes, they say I have not completed 5 years or more. Now, this is violative of page 55. In the first round of litigation, court has observed that I have completed, since I have completed more than 15 years of service, I have a right for re-engagement, also in view of the fact that others are continuing. Now, there is an office memorandum also. That office memorandum was also taken into consideration by the division bench. Now, that office memorandum I had stated in the beginning, page 69, Lordship will kindly have a look. Page 69. 69. My right flows from the order at page 54, 53, and also page 69, office memorandum dated 30/10/2001. 69. I'm reading, Lordship. Second paragraph. After a careful consideration of all the aspects, it has been decided that the WC, Master Roll Worker, work charge employees who were engaged after 1/4/1993, my engagement, admittedly, Lordship, 19/4/1994, and completed 5 years of continuous service as on 24/1/2001, shall only continue in service in their respective capacity, subject to proper verification of their engagement by the respective appointing authorities. Now, this is the right. Then, next paragraph. In implementing the above decision, appointing authorities are also to terminate the service of those MRWC employees who have not completed. Not applicable in my case. So my right is para 2. I have completed 5 years, not 5 years, much more than 5 years. Direction who were engaged after 1/4/1993 and completed 5 years of continuous service as on 24/1/2001. So admittedly, as per para 50, page 55, this honorable court's direction, which has attained finality, not challenged, as per that direction, I have completed 5 years. And there are their own records also, Lordship. While I was in service, there were various orders, internal letters written by them, which I have enclosed in this particular writ petition. I would like to take your Lordship also to those documents, where they have admitted that I have continued for so many years. Lordship will have a look at page 43. At that time, I submitted representation for my regularization. However, that is not my prayer now, Lordship. So those representation, while forwarding those representation for regularization, they have admitted my records relating to service since so many years, Lordship. Page 43, Lordship will have a look, Lordship. Page 43. While in service, I submitted one representation. I'm clarifying my case now is not for regularization. Page 39.
Since when you are not working?
2012.
12 years.
No, 2024.
Yes.
2012.
After that, I have been continuously under litigation. Honorable Division Bench order is 2021, 8/1/2021. Court directed them to pass a speaking order. They passed speaking order, page 6/12/2022. That order is challenged in particular writ petition, this particular writ petition, which was filed on 23. So there is no lectures on my part. And
lectures, I'm not saying. 12 years you are not in a job. How
Lordship,
you manage
this is
yourself?
not a case of compassionate appointment. Lordship, my humble, with all respect, I submit that.
Who said that it's a case of compulsory appointment?
Lordship, delay does not frustrate.
Who said it's a delay? I'm just saying
yes
that during these 12 years, how could you manage yourself?
Very difficult, Lordship. Single lady, very difficult. Now she is 51 years, and if she gets, if this decision comes to her favor, then she will only be allowed to continue for some more years without any retirement benefit, nothing, Lordship.
Yes, there was a finding of this. He has completed.
we have filed
he has
affidavit.
completed for 15 years. Thereafter, he was sent to some other branch.
There is no continuation of service.
Continuation.
Our affidavit.
Your rejection is that she has not completed
5 years.
But there is a record by this court that she has completed 15 years.
No, my lord,
How do you have contradicted?
thereafter the petitioner went to the my lord, division bench. Division bench also rejected it and also dismissed it.
No, division bench
So, my
directed.
lord, our lordship kindly say our affidavit kindly go through it.
Yes.
how long affidavit filed by the Deputy Commissioner, my lord.
Yes.
Can you see the response 4? With regard to the statement, the petitioner different backs to state that as per available office record, Srimati Nazma Begum along with 5 others were engaged temporarily on piece work basis, not a master worker or workers basis, and not appointed against any sanctioned post. Not any sanctioned post. Hence, the authority reserve the rights to terminate such engagement as and when deemed appropriate. With regard to the statement made in paragraph 9 of the deed petition, the deponent begs to state that the same are matters of record, but the deponent does not admit anything contrary to record. Deponent denies the claim made by the petitioner that she was engaged in daily wage basis. Her engagement was on piecework basis, which is not covered under.
Means
Piecework means today is necessary, today this office, today is necessary, this office, this and this piecework, manner. So covered today is the marriage office, today register office, today deputy commissioner office, like that, manner. Just manner the daily wages, manner. Basis which is not covered under the master of workers charge. As such, the engagement is done for completion of the specific work, and there is no scope of re-engagement after. What's the time is after two manner at 2.
Lordship, I had relied on the OM dated 30/10/2001. I have already shown Lordship. Now, Lordship, their own records will reveal that I have been working continuously, Lordship. And although continuity is not a factor under this office memorandum, but continuity I will show, Lordship will see page 39. Page 39, I submitted one representation. That representation was forwarded by them repeatedly, stating that I was continuity as a forwarding letter. That is there. And Lordship, this ground which they are taking now, piecework
He has not completed.
Yes.
Affidavit filed on behalf of respondent number 4.
Yes, my lord. Deputy Commissioner.
Para? The reading is para?
Paragraph, my lord, Lordship, can you see paragraph 7, 112 page. Deponent begs to state that same are matters of record, but the deponent does not admit anything contrary. Deponent denies the claim made by the petitioner that she was engaged in daily wage basis. Her engagement was on piecework basis, which is not covered under MRW and workers. As such, the engagement is done by completion of the specific work, and there is no scope for re-engagement after the said work is completed. So, piecework basis, that means where is needed, where necessary, ask her, you come and do it. And if work is not there, but engagement does not arise. With regard to the statement 8, paragraph 8, my lord, deponent begs to state that judgment of the Honorable High Court in WPC number 2099/2013 is not denied, but the deponent denies the claim of the petitioner reflected therein that similarly situated persons are continuing in service. All such persons engaged in piecework basis for various projects were released from their engagement as and when such projects were completed. So, it need basis, my lord, engagement was piece basis, my lord. And next, my lord, Lordship, can you page 11, para 11. The deponent begs to state that even as regards her claim for re-engagement, the fact is that claim of the petitioner reflected in the judgment of Honorable High Court on dated 18/2015 in WPC number 2099 that similarly situated persons are continuing in service is not correct and has denied. All such persons engaged in piecework basis for various projects were released from their engagement as and when such projects are completed. The respondent number 4 taking action on the earlier order explode the scope of regulation. Paragraph 13. The statement made in so and so, the deponent begs to state that Honorable Court had disposed of the earlier writ appeal filed by the petitioner with a direction to the respondent number 4 to consider for re-engagement in her earlier capacity in terms of the office memorandum dated 30th January 2021. In reply to the contents matter, the deponent states that her prayer for re-engagement was examined and it was observed that her prayer could not be considered in terms of the office memorandum dated 30th January 2021. It is to be observed that engagement was on piecework basis, which is not covered under workers or master rule worker. with paragraph 14. The deponent begs to state that in compliance with the Honorable Court's order dated 29 July 2022 in contempt case number 241/2022, the matter of re-engagement of the instant petitioner was re-examined and it was observed that her prayer could not be considered in terms of the office memorandum dated so and so. The decision taken by the respondent 4 was communicated to the petitioner by letter dated 6/12/2022. The same was also informed to the Honorable Court through a communication to the government advocate by letter dated 15 December 2022, which also appears to be reflected in the order dated 15/12/2022 in IA Civil 3506/2022. The paragraph 15. The statement within paragraph that begs to state that petitioner was engaged temporarily on piecework basis and not appointed against any sanction post. That is important, my lord. There is no sanction post, my lord. Hence, the authority reserves rights to terminate the engagement as and when deemed appropriate, without assigning any reason thereof. As such, the petitioner's claim for re-engagement could not be considered in terms of the dated office memorandum dated 30th October 2001. In this regard, it is stated that engagement is not covered under master worker. This is the stand of the respondent. So she was piecework basis. Just suppose today one man is required to help the office in the marriage office, and tomorrow will be the register office, and thereafter the treasury office. Like that, she was engaged earlier, and now 12 years has elapsed. It is not possible. It's not possible on the part of the courts also, to direct them to re-engage. Re-engagement, what does it mean? There is no work. There is no post sanction. Against whom petitioner will be engaged? That is the question. And now, is to be engaged, there has to be approved from the finance department. I think finance department is not made party. They are not appearing. There cannot be after 12 years of lapse it cannot be. And engagement is need basis work basis engagement. So there is no work, there is no engagement. Hence petitioner has no right temporary person engaged on need basis has a has the right to be considered for re-engagement. Re-engagement means again the same post. What post? There is no post, no sanction post. Only need basis. Suppose if today the High Court requires some persons for NCC person. NCC is broadband, and they are working for 2 days. Their work is completed. They release. They are not entitled for any regulation or entitled for any re-engagement. That is up to the authority concerned. Authority concerned for engagement or re-engagement, whatever may be, need basis, work basis engagement. That is my submission, my lord. But you had petition, no has the right to be considered.
No, earlier first writ petition, it was recorded that.
That is recorded, but that has been boiled down now, my lord. They have filed a writ appeal also. Writ appeal also, policy page 90, 60, 105. No, my lord. The earlier, this is 69, I think.
93, sir.
90, writ petition, my lord.
Writ petition.
And also writ petition, my lord.
90.
And also lordship policy page 90. This is your petitioner's my lord, writ petition 394 of 2007, page 90. This is also, my lord, the case, my lord. The earlier the approach this honorable court by 2099. That is 2099. That is mentioned in this case. It is order 2021. 8 January 2021. I am reading, my lord. Petitioner on the earlier occasion, she had approached this court by filing a writ petition 2099, which was disposed of by order dated 18/2/2015. This court by approached order had observed that considering the petitioner had rendered her service for 15 years, her case for re-engagement be considered along with a similarly situated person. In compliance with the same, Deputy Commissioner Kamru had passed an order 16/6/2016 holding that prayer for re-engagement of the petitioner cannot be entertained in view of the present legal position. The said order is subject to subject matter of the challenge in a present writ petition along with the approached prayer to direct re-engagement. This has been challenged earlier, my lord. The Dr. So-and-so, paragraph 4. On the other hand, P. Nayok, Learned Standing Council, General Administrative Department, as well as Finance Department, Assam submits that Regulation of service cannot be claimed as a matter of right, and condition laid down by the Honorable Supreme Court has to be fulfilled, which has not been done by the petitioner in the instance case. Now, long tenure of service rendered on ad hoc basis may be fact. The alone would not create a right upon the petitioner to claim regulation unless she fulfills the other requirements, including service in the sanctioned post. Rival submission of parties have received the due consideration of this court. Records produced before this court revealed that services rendered by the petitioner were not engaged as sanctioned post, and therefore one of the essential requirements for directing regulation is not fulfilled. In their view of the matter, this court is of the opinion that no case of interference by this honorable court in exercise of power. Dismiss.
95.
Yes. Next case, Lordship, page 93, writ appeal. In writ appeal also, my lord, that was hard. The last page of 96, the writ petitioner shall be liberty to make a prayer before the authority for her re-engagement in accordance with the law, including the aforesaid.
Page 95, third paragraph.
95, yes. Although we do not find any merit in this writ appeal as to the regulation of the petition, and we are completely in agreement with the findings of the learned single judge on this aspect. Yet, since the aspect of the re-engagement has not been considered by the learned single judge, and since there is already an office memorandum dated 30th October 2021, which provides for re-engagement of workers, casual and ad hoc employees subject to fulfillment of certain conditions, we dispose of the writ appeal with a direction to the registered respondent to consider the case of the writ appeal petitioner for re-engagement in the office of the Deputy Commissioner Kamrup Metro in an earlier capacity, in accordance with the law presently in force, including the office memorandum dated 30th January 2021. In case the writ appeal petitioner removes the application for re-engagement, we make it clear that dismissal of the writ petition filed by the writ appellant or writ petitioner will not come to an way case with the writ appeal or writ petitioner moves an application for re-engagement. The appellant writ petitioner will be at liberty to make a prayer before the authority for re-engagement. That is the only direct observation. To make they submitted a representation that has been rejected by the court. Authority.
Conditions of 2000, office memorandum 2001.
2001, that is only for casual employees, those who are ad hoc employees who are doing.
Let us see where it is.
That is.
I have already read, Lordship, page 69.
So,
Second paragraph.
yes, Malad. I am reading it, Malad, whole payment. The GOV examined the question of continuation of master workers, workers, employees engaged after 1493 who have completed 5 years of continuous service pursuant to order of Honorable Guwahati High Court order so and so, so and so. After careful consideration of all aspects, it has been decided that the master worker, workers, employees who were engaged after 1/4/1993 and completed 5 years of continuous service on 24/1/2001 shall only continue in service in their respective capacity subject to proper verification of their engagement by the respective appointing authority. All the appointing authorities are hereby requested to ensure that no further engagement are made by them without prior approval of the SLPC and Finance Department. If any appointing authority makes any engagement in violation of the above directives, he will be personally responsible for payment of wages, salaries, so and so. In implementing the above decision, the appointing authorities are also to terminate the service of master workers, workers, employees who have not completed 5 years of service. This partially modified. This is only for examining workers and master worker. Apparently, it is a fact that petitioner was not a workers or a master worker. She was a peace work needs basis. She was engaged. So he is not a master worker or not a workers, not a particular peace work. This circular does not cover otherwise. That's why, my lord, this our affidavit says she was.
Where is your appointment order?
Engagement letter, initial engagement letter, Lordship will find at page 33. Page 33. This is piecework, 25 paise per 100 bytes. Piecework.
Page
33. Page 33.
Yes.
Showing the names of persons engaged as data entry operator. Third, Nazima Begum, serial number 3. 25 paise per 100 bytes. Now, piecework basis, if I may submit, Lordship, piecework basis, this is the terminology they have coined for the first time in this particular writ petition. All throughout since 2012, they have not used this term. Even in the impugn order at page 105, they have simply stated 5 years I have not completed. And Lordship, I have got a judgment of Honorable Supreme. What they have stated, judgment I will take to Lordship to page 7, running page 122, their affidavit, how they have defined piecework basis. A person who has been engaged, Lordship may kindly come to page 122, how they have defined piecework basis. It resembles the definition of work charge basis as defined by Honorable Supreme Court in Jaswant Singh, page 122. What is piecework basis? What is piecework basis according to them? Page para 7, page 112. Para 8, sorry, Lordship. Para 8. With regard to the statement made in paragraph so and so, the deponent begs to state that judgment of the Honorable Court dated so and so is not denied, but the deponent denies the claim of the petitioner reflected therein that similarly situated. All such persons engaged in piecework basis for various projects were released from their engagement as and when projects were completed. Means it is for some project, and when project gets over for particular purpose, for particular work. Now, what is the definition of work charge basis? It has been defined by Honorable Supreme Court in Jaswant Singh and others versus Union of India. Lordship, 1979, 4 SCC 440. Relevant para I am reading, page para 42. I am reading, then I am providing the copy, Lordship. Para 42, the entire strength of labor employed for the purposes of these project was work charge. The work charge employees are engaged on a temporary basis and their appointments are made for the execution of a specified work. From the very nature of their employment, their services automatically comes to an end on the completion of the work for the sole purpose for which they are employed. So this is the definition of work charge. There is no distinction. This is the term they have coined for the first time to exempt themselves from the word work charge. Otherwise, nomenclature, nature of work charge, piecework, what they mean to say is the same thing. Again, if I read Lordship,
all similarly persons, they have also been discontinued.
My case, I am not banking my case on the ground that others are continuing disengaged. I am not banking on that, Lordship. Their
When they say that you were engaged on a particular project or scheme or a particular work, and the moment it
completed.
No, that is not their contention. That your project is over. Their contention is only that, Lordship, I have not completed 5 years. That is not their contention that the work in which you were working, project against which you were working, that project is over. That is not their contention. Now also many are there.
How you can direct them to re-engage when there is no post, when there is no work?
Post, the issue of post, sanction post, all these things comes when it is a case of regularization.
And this master role worker and work charge employees, maybe the similar terminology, but then your appointment is on a particular post, data entry operator.
Yes. It is against work. Lordship will see, para 33, it is against particular work they are paying me, Lordship.
Yes.
25 paise per bytes. It means it is against that work. It is work charge, Lordship. That is the definition of work. It is against work, it is against project. That is not their contention that the project is completed. I happen to work under the DC. People under the DC were still continuing while I was sent to the marriage officer. Under the marriage officer. Now, under the marriage officer, some new people had come against that. I was made to go. But I had completed the 5 years term as per this OM of 2001. My right had accrued under that OM, and I am duly covered by that OM. There is undisputed facts regarding
OM relates to master role
work charge and master
work charge. And work charge.
The petitioner neither work charge nor a master role.
Mine is
import any deposition on it.
No, this is work charge only, Lordship. Mine service is work charge. Piecework ground, they have taken for the first time. Again, Mohinder Singh.
See, where we should, how can we direct them to engage you when there is no post?
No, post will come.
Job is not required.
That they have never stated.
At that point of time, right?
No, let them say, Lordship, it is not required. Work charge workers are not required. Nowadays, now also, Lordship, computerization of all sale deeds, all, that was my work basically in data entry operator. I was working in the computerization section. All documents were computerized. Now also computerization of all the documents are still going on, Lordship. I don't know when it will be completed. It is an age of digitalization, Lordship. Computerization works are still continued and they are paid on work charge basis. And I was also paid on work charge basis. Whenever they will call me, I will go, or whenever they, what work they will, I will do on the basis of that they will pay me. I will not make any claim regarding to.
Where is that impugn order?
Impugn order page 105. 105. Their only contention, Lordship, I have not completed 5 years.
Corroborate to your claim of continuously working this or in the office of service for a period of 5 years or more.
They do not say, Lordship. They do not say, Lordship, that there is no work, no project has been completed. Again, Lordship, Mohinder Singh Gill, as per Mohinder Singh Gill, Lordship, they cannot supplement the grounds, piece work, no project, all these things, they cannot supplement by way of affidavit, Lordship. The only ground they have taken is this one, Lordship. That 5 years I have not completed. And that 5 years is an admitted fact as per decision of this Honorable Court and their own records.
Not only that, my lord, I would like to inform you that the records available in this establishment do not corroborate your claim for continuously working. There is no record is working continuously.
Records were placed before the court when the court passed the order, Lordship. And I can show record,
So,
Lordship.
my lord, this order, there is no infirmity, my lord. Petitioner's engagement.
On what basis you are saying that she has not completed 5 years?
Not completed for 5 years. There is no record, my lord, completing 5 years.
The record has been recorded in the.
The record has been said in earlier occasion, my lord.
15 years. Thereafter, she was transferred to sub-register.
No, my lord.
Recorded in the first rate petition.
Read petition that has been recorded earlier. That was not, my lord, properly instructed by the authority to the government advocates, my lord. I don't think. Subsequently, the petition filed. Subsequently, yes, I can produce the records, my lord, whether this is continuing or not.
Because this is of 7/7/2004, right?
Yes, my lord.
When she was discontinued.
2022.
12.
Yes. No, 2000. No.
Yes.
Earlier.
12.
2012.
38 page 38. They have used the word released. They have used the word released, Lordship. On that particular day, I was released. According to page 38. Page 38. And they, in the reply, they say it is not daily wage.
Personnel engaged on daily wages basis in registration branch DC office are hereby released with effect on 12. Yes.
Para 7 of their affidavit, they say I am not engaged on daily basis. Here
yes, it's against the record, sir.
It says
she was engaged in 2004,
1994,
and then released on 2012.
1994.
The flowing personnel engaged on daily wage basis in registration branch. Malot registration branch in the department, malot, for daily basis. But other department marriage officer like that, other officers not engaged like that, malot. See, only it says only malot registration.
No, why you have said that 5 years?
5 years, malot. This office memorandum says only those who were continuing for 5 years, the workers and master workers. Actually, this word should not be there because she was not engaged like a master worker or workers.
Perhaps, Lordship, they have counted 5 years in the sub-register office, not from the initial under the DC. Perhaps that
a different office.
Maybe, Lordship. But in the government of Assam, as per 300 and OM of 2001, I have completed not only 5 years, more than 15 years. And there are other records that will show, Lordship. Next page, Lordship will see page 39. 39. While I was in service, I was submitted one representation. I, along with those all those 5-6 people who were working, I submitted one representation.
Can you produce the record?
I'll call it.
Otherwise, these records shows that she has completed more than 15 years.
As per this order of the read petition, they says continuously. Whether the government advocate was properly instructed by the authority or not, I don't know.
You just simply see
The subsequently
page 33 and page 38.
38 years, but I have seen
When she was not complete.
38 page 38 only.
If she was not continuing, with the question of release.
Page 37 also smooth functioning of the marriage office, senior sub register office, Guwahati, for following distribution of works amongst the contractual basis, employee of the branch has been made under. So and so petitioner was also engaged on 20th June 2012, join her. And thereafter, for page 38, the following personnel engaged in daily basis were released.
Lordship, all marriage, sub-register, all are in the DC office only, Lordship. Page 43 will also show I was engaged since. Page 43 will also show. Page 43, then page 46. Page 43 will also show, with reference to the subject above, I have the honor to inform you that you had Sri Onil Sharma and 5 others were engaged as data entry operator since 1/11/1994. Since 1/11.
Yes.
This they say in
I will see the
2003.
record. I will
This-
put the
this-
record.
Everything is there. Lord.
Record is there.
No, I will.
Is here.
No, not my lord, not clear, my lord, because my
Your
re-engagement
impugn order
after
says
12
that she has not completed 5 years. Therefore, her case has been rejected. Now you are saying that she is not an WC or master roll worker. Therefore,
master
she
worker
cannot
nor
be.
boxers. Not master worker nor malad is a boxers. She is did work need basis malad engaged. That's why that was released. So there is no post to re-engage.
I'll record it. Mr.
Vijay Sharma, Lordship.
Landed Council for the
I will be making the submission on behalf of the Finance Department.
Yes. You filed the affidavit.
No, my lord. I will be limiting my submissions to the point of law.
Yeah.
I will show that my lord, the relief claim is not my lord maintainable, as well as the writ petition itself is not maintainable. If for a moment my lord come to page 30 of the writ petition, that is the prayer portion. Yes. In the prayer portion, my lord, lordship, my lord, the first prayer, writ of mandamus shall not be issued to set aside order dated 7/7/2012. 7/7/2012. That is the order of release, Annexure 4. Now, Annexure 4, if I see at the writ petition, my lord, I find that it is mentioned as follows: the following personnel engaged on daily wage basis in registration branch DC office Kamrup are hereby released with effect from 30/6/2012. There, lordship will find the name of the petitioner, Srimati Nazima Begum, at serial number 3. This release order passed way back in the year 2012 have been impugned herein in the present writ proceedings. Number 1. Number 2, my lord, a direction has been sought, my lord, to re-engage the petitioner. To re-engage the petitioner, meaning thereby there is a continuity in service. There has to be a continuity in service. It cannot be a fresh appointment. She is not seeking, my lord, a fresh appointment. She is seeking a re-engagement, meaning thereby she has just, my lord, played with the words, and instead of regularization, she has used the word re-engagement. Re-engagement, if this honorable court allow, would amount to, in my respectful submission.
Sir, all this has boils down to observation of the Honorable Division Bench.
Absolutely. Therefore,
it says directed to consider, or as in terms of the 2001 office memorandum.
Yes.
Right.
Yes, my lord.
She has filed an application for re-engagement. It was considered and rejected on the ground that she has not completed 5 years.
She has not completed 5 years. That is one aspect of the matter. But
No, that is the only the aspect of the matter, not one aspect.
no, my lord, why I am making that submission? Because, my lord, in the earlier writ proceedings, this order was put to silence. This is the genesis. This order dated 7/7/2012 is the genesis, is the very foundation of the present writ petition, which was also impugned in the earlier writ petition. So my first submission will be, my lord, that this writ petition is barred by the principles of res judicata. One cannot, my lord, agitate the same issue on the same facts. That is my first submission.
Yes.
My lord, the second submission will be, my lord.
Your first submission is rejected.
Yes, my lord, I am obliged.
Considered and rejected.
My lord.
Then
Now,
second submission.
Second submission will be, my lord, that even if we assume the petitioner to be a daily wage earner, for a moment, I assume, I term herself to be a daily wage earner, or, my lord, works as employee, which has been heavily harped upon by my learned colleague. I have heard his submissions. He says that, my lord, this work primarily pertains to a work which is done by a work charge employee. Now, if a work charge employee, my lord, let alone, my lord, all the notifications memorandum, what is the law laid down by the division bench of this honorable court? Now, I will be relying on the decision in Upendas. Upendas lordship is aware that pertains to, my lord, regularization of master roll workers as well as work charge employees. So Upendas, my lord, says, paragraph 23, Upendas division bench decision. For the reasons we are of the view that in the fact situation of the case, master roll workers, work charge workers, and casual workers are not entitled for regularization of their services with consequential benefits such as pension, etc. So therefore, she is not entitled for regularization. If we draw an analogy of the dictum pronounced at paragraph 23 and apply it to the fact circumstances of the present case, we find, my lord, that the re-engagement is also not permissible in view of Upendas. Now she will have to overcome that. So Upendas will stand on her way. Upendas says, my lord, master roll workers, casual workers, work charge employees, none of that category of employers are henceforth, my lord, entitled for regularization. Now, if the petitioner is allowed to re-engage, if the authorities are directed to re-engage the petitioners, that will amount to regularization because that will be a continuity in service.
We'll make it clear that the re-engagement shall not be considered to be a regularization.
That is true, but but her right will have to flow from some legal basis. So what is the legal basis? The legal basis is maybe, my lord, that office memorandum.
Office memorandum coupled with the observation of the division bench.
Division bench observation, therefore, my lord, if lordship allows me, my lord, division bench decision.
Yes.
Because the writ petition was, my lord, not entertained by this honorable court.
Page 95, para 93.
Yes.
95.
Page 95, my lord, the third paragraph. If lordship allows me, my lord, for my satisfaction, may I read it?
read it. You read it for
my lord, I'm so deeply obliged, my lord. I'm so deeply obliged. Although we do not find any merit in this writ appeal as to the regularization of the petitioner, kindly see, my lord, there she has paid regularization. She has now, no, I am going by the division bench dictum.
I will clarify this.
Yes, kindly do not interfere. Although we do not find any merit in this writ appeal as to the regularization of the petitioner, and we are completely in agreement with the finding of the learned single judge on this aspect, yet, since the aspect of re-engagement has not been considered by the learned single judge, and since there is already an office memorandum dated 30/10/2001, which provides for re-engagement of workers, casual ad hoc employees subject to fulfillment of certain conditions, we dispose of the writ appeal with the directions to the state respondents to consider the case of the writ appellant and writ petitioner for re-engagement in the office of the Deputy Commissioner Kamrup Metro in her earlier capacity, in accordance with law presently in force, including the office memorandum dated 31/2001. In the in case the writ petitioner appellant moves an application for re-engagement, we make it clear that the dismissal of the writ petition filed by the writ appellant writ petitioner will not come in a way in case the writ appellant writ petitioner moves an application for re-engagement. That is what has fallen from my lord's mouth. The writ petitioner, writ appellant will be at liberty to make a prayer before the authority for her re-engagement in accordance with law, including the aforesaid office memorandum dated 30/10/2001. So 30/10/2001 is only one facet of, my lord, the principles that is to be taken into consideration.
Now,
yes.
Now they have considered that rejected her prayer.
Yes.
Only on the ground that she has not completed 5 years.
Yes. Now, my lord,
they have not said it doesn't apply. This office memorandum doesn't apply. Right.
My lord, yes.
Doesn't say that the office memorandum 2001 doesn't apply, though they have tried to project in the affidavit.
Yes.
But the impugn order says something else.
The impugn order
says continuation, non-continuation recorded in the first writ petition. 15 years, completed 15 years.
Yes. Now, my lord, if we read that impugn order, my lord, that is after consideration, her prayer was rejected. Yes, my lord, I'm reading it. In view of the subject and letter cited reference, I would like to inform you that the records available in this establishment do not corroborate your claim of continuously working in this office. Records or in the office of sub-registrar for a period of 5 years or more. Now that is a question of fact.
No, that has been recorded in the first writ petition.
It might have been recorded, my lord, but
nobody has disputed that.
No, lordship.
And the document which Mr. Sir, the document which he has annexed, it shows that appointment in 1994 and then 2004, and then you have released her in 2012.
That is true, but my lord, this order
There's
says
nothing contrary to that. There's nothing on record to show that she has not been completed 15 years or 5 years. Only you are saying that of records doesn't corroborate.
Records,
but records annexed here, coupled with the record, recorded by this court in the first writ petition, it clearly shows.
No, it clearly shows.
One could one could have understood that if the opposition memorandum 2001 is not applicable, which is Mr. Trude has projected, because this is not an work charge employee or a master role worker. It's not the case in the impugn order. Just because she has not completed 5 years, which record speaks otherwise.
Records may not speak the
And it's been recorded by the court.
Absolutely, my lord. I always go down, my lord. Now, my
therefore,
lord,
it's no question of regularization.
No,
only re-engagement as per the, if she is entitled under 2001, because your reason of rejection is contrary to the records. Although you have said record doesn't corroborate, but the records annexed, that too recorded by the court in the earlier round of litigation.
Absolutely.
So that she has completed 15
yes.
years.
Now, my lord, only one anxiety, my lord, which falls upon me, my lord, will be, my lord, whether the petitioner was in continuous service, because she might have worked for 15 years, she might have worked for 20 years, but whether it was whether there was a break in service or continuous service, that is most important.
Who has stopped you to record all these things while rejecting his case?
Therefore, my lord, therefore, if lordship would be pleased, to see the records. If the records are available, instead of, my lord, disposing in the repetition by today itself.
Can you disbelieve the order of this court?
No, order of this court. Nobody, my lord, nobody. There is no quarrel with the order.
Where is this order?
Lordship and
first order.
First order, kindly let him show that he was in continuous service without a single break. Yes, that much.
Shall I show that, Lordship? Continuous service. Another document I can show, Lordship.
Before that, my lord,
Initial.
That 2001 office memorandum, if lordship permits.
2015 order, page 53.
Release, Lordship, with 38.
Page 53.
38.
Release order is page 38.
And single judge initial order is
page 55. Having regard to the above and considering that the fact that the service of the petitioner was utilized by Deputy Commissioner for more than 15 years before shifting her to the office of the Senior Registrar, is directed to consider re-engagement of the petitioner in his establishment.
Yes, therefore, lordship will kindly say, my lord, it was not a mandamus per se, and there is no categorical finding.
This has been recorded clearly.
No, my lord, recorded, but whether she was in continuous service,
considering the fact, sir, considering the fact that the service of petitioner utilized for more than 15 years.
Absolutely correct, madam. Maybe, my lord, maybe. Therefore, my lord, a person in service and person in continuous service, these are two different connotations. My respectful submission, lordship will kindly appreciate. A person in service, there may be a break. Therefore, the question issue of re-engagement has arisen.
Lordship may even record it. Lordship may even record it that I will not claim my past service.
Sir, it reminds me the famous in America. Have you seen that Steve Harvey?
Steve Harvey.
A child of 3 years.
Yes.
He said, "Don't interrupt."
Oh, I'm sorry.
When I'm talking to the Mr. Harvey, a 3 years old boy, Therefore, when he's
I'm sorry.
you don't interrupt. You'll be given a chance.
Therefore, this 2001 office memorandum speaks of continuous service. It is the reason, my lord, why I am making this submission, my lord.
Why, who has stopped you to give that reason? Why you have said
No,
she's hasn't complete 15 years?
Therefore, 15 years, my lord, there are three facets now. One at page 55, which is the finding of the coordinate bench of this honorable court. Lordship is bound by that, my lord, there is no quarrel. At page 55, the finding where the finding of this honorable court is there is not a categorical finding that she was in continuous service. Whereas, my lord, Lordship will kindly be here, whereas the OMs use the term continuous service. At page 55, that is the...
You apply to your friend that Steve Harvey's case. Don't interrupt when I'm talking.
I apologize.
Yes, I've understood.
So there is not a categorical finding of
Well,
continuous...
directing you to consider for re-engagement.
Then my lord will kindly...
Whatever reason you may give, you may give.
My lord, for my satisfaction, that at
In
page
any
69,
case, in any manner, we are not directing you to regularization. We are directing for regularization only to re-engage. Consider the re-engagement. Having considered that your rejection is contrary to the record that she has not completed 5 years.
that means lordship is not issuing any mandamus per se.
Yes.
Therefore, my lord,
We cannot.
Yes,
We
my lord,
cannot.
I'm so deeply obliged, my lord. Only for my satisfaction,
We'll record everything.
Yes, my lord, paragraph 2 of that OM.
Yes.
I am making that submission.
Yes, yes.
I have to be very
Read it,
particular.
read it.
Yes. After a careful consideration of all the aspects, it has been decided that the master role workers, works as employees who were engaged after 1/4/93 and completed 5 years of continuous service.
Yes.
Continuous service. So it has to be continuous also. There may not be one single day break also. But here, and applying this, my lord, we find that the impugn order, that is, my lord, 22 order, earlier 2012 order that has now attained finality in view of, my lord, honorable court's dictum. Now 22 order says there are no records are available, do not corroborate your claim of continuously working in the service. So therefore, I defend this order. I say, my lord, it is as per with the office memorandum. A person in service and a person in continuous service are two different situations, two different legal
He
connotations.
may have worked for 15 years, but then there was no continuity.
Continuous, that is, I'm so deeply
Show
obliged.
us any document that she was not in continuous
So
service.
therefore, the record say, now if lordship pleases, my lord, my senior colleague will bring the record. That's what. No, my lord, the record say, my lord, the impugn order says continuous. Otherwise,
Heard, mister. Then we'll see the record. Because
I have enclosed, Lordship, page 43.
I find that this court should give a direction consider re-engagement, but then since they are vehemently opposing it,
No, but I have
we
enclosed the
would
record.
like to see the record.
That continuity I have enclosed, page 43. I have enclosed.
I'll put it
I
in the
have
record.
enclosed.
Record will be revealed.
Yes, let us see the
Lordship
record.
will may have a look, Lordship. Page 43.
If you have been
I
in a
require only-
service continuously for 5 years,
That page 43 will show, Lordship. Lordship, may for a moment, Lordship. For a moment. Page 43. This is the forwarding letter of my representation at page 39. I gave representation while I was in service for regularization, which is at page 39. Now, page 43, Lordship will see, with reference to the subject above, I have the honor to inform you that you had Anil Sharma and 5 others were engaged as data entry operators since 1/11/1994. And this they have issued on 1/8/2003. This is one document. Then Lordship will see page 46.
I will pause a little. I'm interrupting, my lord. There is no mention of continuous service.
Since they have not mentioned that it is it is breaking service.
Nobody is denying.
Nobody
Nobody is denying.
And also had Mr. T.C. Shetty, learned counsel. You are
My lord, R. Borpuzai for Finance Department.
respondent number.
Respondent number, my lord. 5, my lord. 5.
Respondent number. Who is one? Mr. So
One and two.
Study girls for respondent. NTC should have for respondent number. Additional senior government for respondent number 4, and Mr. Akbar Pujari, Legislative Council.
3 and 4.
Finance Department for respondent number 5. Next para. Having considered that having considered the submissions of the land counsel for the parties and also perusal of the reports. Come on. Since the issue is as to whether the petitioner has put in a continuous service of 5 years, the respondent, Deputy Commissioner, respondent number 3 and 4. Mr. TC should be learned counsel appearing, learned additional senior government advocate appearing for respondent number 3 and 4 is directed to produce the record.
Lordship, 5 years as on 24/1/2001.
Yes, we'll see. Record with whether you have had a put in the continuous service or not.
As per OM, 5 years as on 24/1/2001, Lordship.
We'll see.
If she can fulfill, my lord, we are nobody to stop her. If she can fulfill, we are nobody to stop her.
Hearing when, sir?
The 2 weeks, Malad.
When?
It's the old records, Malad. I will have to call them to charge.
12 days, we're keeping it for, we're keeping it part hard.
No, Lordship, may kindly take this part hard, my lord.
Yes.
Lordship has heard it at length.
We have spent considerable amount.
My lord, I'm so obliged. I'm so obliged.
Just after 2 weeks,
Can it be on 12th?
as a part hard.
On 12th of November, can it be?
12, we have picked so many matters, right? 18 can be 18. 14 or 18?
Can it be on 15, Lordship? 15?
15 November appears to be a holiday.
I'm sorry.
14
November, yes. Thursday, my lord. It will be a hearing day. 14 November.
Yes.
Obliged, my lord.
My pleasure, Lordship. This matter, Lordship, Land Tribes Department is supposed to.
My lord, I am appearing for the department here. They are the employees of a corporation, my lord. The corporation is in very bad shape regarding financially. So, my lord, we are trying to give them some granting aid.
Yes.
So, my lord, that is on the last occasion I was asked to, my lord, seek instruction regarding the position of the granting aid, my lord.
18.9.
Yes, my lord. So, my lord, my instruction is that, my lord, the finance department raised a query regarding that whether we have any concurrence from the judicial department, my lord. So, we have sent the thing to judicial department for concurrence. So, judicial department, my lord, day for yesterday, we have received the note. So, now, basing on that note, we are again, today or tomorrow, we are forwarding this to the finance department for FS, financial sanction, my lord. That is my secretary. Just now he has told me, my lord. So, my lord, so basically, my lord, these are granting aid. We are out of the way. We are going out of the way to help them, help the petitioners, my lord. Otherwise, my lord, they are employees of corporation, my lord. So, we are not, my lord, bound to, but still, we want, my lord, to help the petitioners and the corporation so that it keeps floating, my lord, and everybody's, my lord, in a benefited, my lord. So, my lord, we need further some time since
you are granting what they are asking.
Granting aid, my lord.
No,
Granting
granted
aid.
Granting
aid to meet, my lord, this area salaries, my lord.
You are still in the job.
No, they have retired.
Retired.
They are retired employees of the corporation, my lord. The
Yes.
corporation doesn't have money. It's in a very bad shape. That is what they said.
Who is for the corporation?
Corporation, my friend is appearing.
You are depending on the grants in aid. You withdraw the rate petition. Will allow you to come back. We'll close the matter. They are under process.
Lordship, dips 110, Lordship. Lordship,
You will allow you liberty to come back as and when because you don't have a right to ask for this from the state. The state is ready to But they are
Lordship may kindly
they are
come to
gracious
the.
enough to
yes.
help you out by
Yes.
processing the granting aid.
Yes.
So why you should put them on a warning
No.
that this is in the court and all those things. You cannot put pressure
Lordship,
on
no,
them.
Lordship. Some of the petitioner has already granted Lordship.
And in case if the corporation fails to do that, you will file a suit.
Lordship may kindly see the order.
Then, my lord, the process of liquidation is also there, my lord. They will have their.
Lordship may kindly see the order, Lordship. Similar person, Lordship, has already got the benefit, Lordship. This one I
We,
would
we gave them granting aid.
Yes,
That is also we gave granting aid.
They are ready to give
No,
you.
Lordship. This matter also kept us pending, Lordship. Since after that, Lordship, they have
We gave,
released the
that is what
payment,
we gave
Lordship.
granting aid to those
Will record
petitioners.
his submission.
After that, Lordship,
Although
have
they are not mandated to provide you, the state. It is the corporation. If the corporation doesn't have the money, right?
Lordship may kindly see the order.
No, these are the cases where the grants in aid was already.
Yes, Lordship. After
Approved-
filing
accord-
of this
accord-
writ petition, Lordship, granting it was processed, Lordship.
Yes. You cannot file a writ petition by a threat.
No, Lordship, this is not threat, Lordship.
This is a case where they have said already granting aid also been released
Yes,
by the
Lordship.
government.
After filing
In
of
that
this,
case only this has been allowed.
after filing of that writ petition, those writ petition, Lordship, they have sanctioned the granting.
That's what I'm saying. You cannot file a writ petition by a threat.
Lordship, may give one
You are
week time.
threatening the respondent.
No, Lordship. Otherwise, Lordship, our Lordship, it is not disputed fact that
It's as good as AK-56 bullet.
no, Lordship. Lordship may give 1 week time.
Why? Why closing it? Because they are and
Lordship, kindly keep
granting
this
aid is
pending,
under
Lordship.
process.
Otherwise, Lordship, they will not.
Well, what is your stand?
They will not get anything, Lordship.
You don't have anything against the government. You will have to. go
Yes,
to the
Lordship. They have
corporation.
filed their affidavit, Lordship. They have not
Corporation,
denied,
what they are
Lordship.
saying? Saying what?
Dispute regarding the amount and everything, but we need to receive some granting because we are not having enough money.
So they are saying that they are for granting aid, they are under process.
That is why, Lordship, my
Let them,
humble prayer
let
before
them
your
do
Lordship. Lordship may kindly keep this pending, Lordship. Otherwise, they will not get anything, Lordship.
Keeping it pending is a threat
No, Lordship.
to the state government.
No.
Nobody disputing your entitlement.
Yes, Lordship.
What they are doing is there is no money. Corporation doesn't have the money. Therefore, they have asked for a granted aid. The government, since it's their corporation, they are gracious enough to help you out.
Lordship may give us some time, give them some time, Lordship, for completing the process, Lordship. Lordship may kindly keep this pending, Lordship. Otherwise, Lordship, they will not get anything, Lordship.
We'll give you a liberty to approach
we
again
don't
if
have
occasion
pension
arises.
also, Lordship.
Sir,
They are-
will allow you to give you a liberty to approach again this court if occasion arises, because let them have some breathing space. Just because there's a pendency, you just cannot. That too when they are not mandated.
It will lordship dispose lordship, then it will cause serious prejudice to the petitioner's lordship.
Observation, we'll record your submission.
Not
In
getting
view of that, we are closing the writ petition.
that is why lordship honorable all the in all the dated lordship this matter is kept this pending lordship so that
So
can be
today this
damaged
court,
expeditiously
this
lordship.
court is view that it's no use keeping this matters pending. When the government is graciously taking up your matter, it's under process.
From
We'll
last
say it is expected that the state authority, in
From
view of
last
the,
1.5
in view
year
of the
lordship.
submission made by the learned standing council, we expect that the matter shall be completed, the process shall be completed expeditiously.
time
In fact, we're allowing your writ petition.
and lordship will fix timeline lordship. Otherwise,
Dispose.
Deeply honest, my lord.
lordship 2 month time maybe.
We cannot give them. We'll say as early as expeditiously. All right. That too will hope and trust only. We cannot issue mandamus.
Lordship if no time being no time frame is granted lordship, then it will lordship may given time frame lordship so that it will
You just record that. So and so that will be. What is your submission?
My lord, our submission is that, my lord, we have gone out of the way and we are processing this grant in aid. And that has been earmarked and we are processing it, my lord, and we will give this grant in aid to the corporation so that they can meet the area salary, my lord.
Learned Council, Mr.
Arthur,
Learned Standing Council,
Tribal Affairs.
Tribal Affairs Department. And no, has submitted that the department, the state government in the Department of Tribal Affairs has already processed.
Processing, my lord. Processing, my lord.
Has already.
It's under process, my lord. We haven't completed, my lord.
Has decided to provide granting aid to the corporation for payment of what? Gratuity and
lordship area salary
area
as well as
salary.
pensionary benefit lordship.
So and so, so and so.
Meet
Which
the
is-
claims of the petitioner.
Which is under process. The moment the granting aid is approved and accorded by the state government, same shall be parked with the corporation, respondent corporation. But it cannot be just approximately how many days you would like to
My lord will
require how
grant
many days?
4 months time, my lord. It's a huge amount, my lord. 5.36 crore, I think, total.
4 months.
4 months, my lord. 4 months, my lord.
Which may take 4 months time. Next step. Having considered the submissions of the learned council for the state respondents, you are also agree.
My lord, we will consider as and when the proposal reaches the finance department. Finance department will
Having
consider.
considered the submissions of the learned council for the state, I deem it appropriate to close this writ petitions. Mr. And the close this writ petition is the state, although not mandated under the law, but considering that the respondent corporation is a government corporation, and for the interest of the employees of the corporation, come on, they have the matter has been processed, and then the interest of the employees of the interest of the petitioners, come on, they have decided to provide grants in aid. Mr. It is expected that the respondent authorities expected the process of providing grants in aid would be completed as early, completed as expeditiously. Expeditiously, not later than 4 months from today. It is needless to observe that on according on approval of the on providing of grants in aid to the corporation, the respondent corporation shall disburse the same to the petitioners.
Lordship may grant a liberty to approach this honorable court if
It's liberty is always there. Now I am not, because they said within 4 months they said liberty is always there if there is a fresh cause of action. The writ petition states disposed of. Writ petition already. So we have indicated, they have said 4 months. It's fair enough. And so,
Deep level.
this
Yes, Your Lordship. Grievance of the petitioner is against the decision of the respondent number 5 in not allowing her to join in the post of laboratory technician despite appointment letter being issued on the ground that the institute from where she has obtained the diploma in laboratory technician is not affiliated to the Sri Sankardev University of Health Sciences, even though the in advertisement pursuant to which she had applied in the year 2011 does not say so. Lordship may kindly peruse the advertisement at page 22. Is the typed copy of the advertisement. We have typed out the relevant extract of the advertisement. The post of laboratory technician, the educational qualification, page 22, the typed copy. For the post of laboratory technician, the educational qualification that was required was certificate course of above equivalent from any medical college of Assam / recognized institute of government of Assam. That is what it says.
minimum education qualification.
Yes, certificate
Laboratory
course.
technician.
Certificate course of above / equivalent from any medical college of Assam or recognized institute of government of Assam. That is what it says. Either from any of the medical colleges or recognized institute of Government of Assam. That is what the advertisement prescribed.
This is laboratory technician.
Yes,
laboratory technician certificate course.
Yes.
Or equivalent from any medical college of Assam recognized institute. Yes.
Okay. And she applied pursuant to these advertisements. Initially, she was not selected, but the selection of some of the candidates was put to challenge before the Honorable High Court. And by judgment and order dated 27th of September 2022, the selection of some of the candidates was interfered with by the Honorable Court. That judgment is at page 30. Keeping over the cost title, page 30, and the operative portion. And the judgment is relevant for the purpose of this case only to the extent that the selection of some of the candidates were interfered with, and thereafter the select list was recast. Page 49, the operative portion. Page 49, paragraph 31 of the judgment. Having decided the writ petition in the aforesaid manner, it is directed that the vacancies that may arise and may arise shall be filled up by recasting the selected in question on the basis of marks obtained by the candidates in the selection process, and appoint those candidates who are found to be eligible on the basis of qualification as per the advertisement dated 19/2/2012, including the petitioners, except the petitioner number 2 and 4, we have withdrawn their names from the present petition. So what the Honorable Court directed is that
recast the selection.
Yes, recast the selection.
So
and
accordingly,
after
you were
that, yes, I was in the select list. Lordship will kindly peruse the next page at page 50.
Yes,
Office order dated 29. Yes, her name is at serial number 4. The name of the petitioner. She was selected under the OBC. Recently recasted. And thereafter, this is the appointment order. This is the appointment order. Also, after the select list was recasted. Order dated 29/5/2023. Page 50, that order.
Yes, this is.
No, this is the appointment order. Appointment order. This is the appointment order. Based on recasting of the select list. Appointment.
Yes.
After that, at page 52, she submitted the joining letter before the principal comes.
Only 5 of them.
Yes, Lordship.
How many posts were there as per the advertisement?
As per the advertisement, Lordship, 48 posts. 48 posts of laboratory technicians were there.
Then why only? Okay, this is.
Lordship, as it is the selection of some of the candidates were interfered with. So some of the posts had vacancies arose, and thereafter select list was recast in selecting some of the candidates who were not selected at that point of time prior to the litigation.
Okay, you have joined.
Yes, I submitted the joining letter on 23rd of June 2023 before the principal comes in superintendent, Teshpur Medical College and Hospital.
Yes.
I was not allowed to join Lordship next page, page 53. The letter dated 27/6/23, addressed to me by the principal of the Teshpur Medical College.
Diploma in Medical Laboratory Technician course is not recognized.
No, yes.
By
It is found on verification of document that the institute where you undergone the diploma is not recognized by the competent authority. That is what it says. As such, you are not meeting the eligibility criteria as per the advertisement, and in view of the same, your joining letter dated so and so is hereby said to be communicated as not accepted. Then
another letter by the regarding non-acceptance of joining letter at page 55, the type copy, letter dated 10/7/23. I may just read, if I may just read out the relevant aspects. This was addressed to the Principal Secretary, Honorable Chief Minister, by the Principal cum Superintendent at Tejpur Medical College. With reference to the subject cited above, I have the honor to state that as per order of the Honorable Guwahati High Court, 5 numbers of candidates were selected for the post of laboratory technician in TMCA and H, where so-and-so, that is the petitioner, also selected for the same post, subject to verification of their qualification certificate and also other eligibility conditions at the time of joining. On verification of our documents, it was found that the institute where so-and-so undergone the diploma in medical laboratory technician course is not listed in the list of affiliated college institution under SSUHS as on 1/1/2018. This is the reason which they have given, that it is not affiliated under SSUH, that is the Sri Sankardev University of Health Sciences, as on 1/1/2018. Now, advertisement does not say so. And another not very relevant reason cited by them, has submitted a pass certificate from the Institute of Medical and Technology Research without valid signature of the principal, copy enclosed at the time of her joining. As such, she was not eligible to be appointed to the said post for not meeting the qualification criteria mentioned in the relevant advertisement. Hence, the selection and appointment in respect of Kavita Bora for the post of laboratory technician in TMC and H. Tejpur was not accepted. Now, 2 reasons given by them. First of all, that the institute is not affiliated under SHUS as on 1/1/2018. And secondly, the certificate that has been enclosed by her does not contain the valid signature of the principal of the institute. That is what it says. Now, as I have already placed the Lordship, the advertisement pursuant to which the petitioner had applied, and the advertisement in the year 2011 that was issued has clearly stated that either the diploma or a certificate has to be obtained from any of the medical colleges of the state of Assam, or from an institution that is recognized by the state. That is what it says. Recognized Institute of Government of Assam. That is what the advertisement says.
No, laboratory technician course of above equivalent from any medical college of Assam, recognized institute
oblique recognized Institute of Government. That the oblique there, what it implies that either one has to obtain that, one has to get that degree from either of the medical colleges of the state, colleges of Assam, or recognized Institute of Government of Assam. These advertisement does not say that it has to be obtained from an institute which is affiliated to the Sankardev University of Health Sciences as on 1/1/2018. That is the reason they have cited now. And eligibility post advertisement.
No, according to you, as per the requirement, it's only about the certificate course of laboratory technician.
Laboratory technician.
Whether it's from foreign country, national level, or recognized by the
state of Assam, or the medical, or from any of the medical colleges of Assam. Now, as so far as the certificate of the petitioner,
any laboratory technician certificate, number 1, or any equivalent certificate from Medical College of Assam, or any laboratory technician certificate from recognized Institute of Government of Assam.
Recognized by the Government of Assam.
Any 3 of them.
Yes, any. That is what it says. It does not say that it has to be, institute has to be affiliated under the SSUHS as on 1/1.
My lord, in earlier round of litigation, the judgment that my friend has referred to, my lord, if your lordship comes to the judgment, my lord, at page 47, my lord, because the candidature of the earlier candidates, those have been cancelled because they could not fulfill this particular criteria, my lord. That they did not obtain the certificate from a recognized institute of Assam, my lord. On this count alone, my lord, their candidature was cancelled, my lord. If your lordship comes to page 47, my lord, there were, my lord, 5 private respondents, my lord. There were some, my lord, page 47. First is, my lord, paragraph 27. The material available on the record discloses that the respondent number 5 appeared in the qualifying examination in the month of August 2012. The certificate issued by the institution, namely Institute of Medical Technology Research, Tamil Nadu, bears no date nor in the mark sheet issued by the said institution. Accordingly, this court is of the considered opinion that the selection and appointment of the respondent number 5 is illegal for the reason that the said respondent acquired the qualification subsequent to the last date of submission of application. And therefore, such election and appointment is liable to be set aside. Accordingly, the same is set aside. And para 28, my lord, respondent number 6 is also similar. Then your lordship may skip to para 29, my lord. So the respondent number 7 obtained the qualification from Rural Institute of Medical Technology, Jhargram, Midnapur in the year 1999. The certificate do not disclose that it is an recognized institute, in as much as the state authorities are absolutely silent whether such institution is recognized by Government of Assam. Though the silence speaks volume, however, in view of the silence of the state respondent and in view of absence of positive assertion that the same institute is a recognized institute as mandated in the advertisement in question, and also balancing the claim of the respondent number 7, this court is of the considered opinion that a chance should be given to the state respondents to verify the certificate and institution from where the respondent number 7 had obtained the certificate, and it after verification it is found that on the last date of submission of application by the state respondent pursuant to advertisement dated 19/2/2011, that is on 11/3/2011, the said institution was not recognized as per the advertisement. The appointment of the respondent number 7 to the post of question shall be treated as illegal, and the respondent number 7 be terminated from service in as much as it was bounden duty of the employer to verify such fact before appointing the respondent number 7. Then, my lord, paragraph 30, my lord. Similar is the case of the respondent numbers 8 and 9. Respondent number 8 had produced 2 certificates, one dated 30/4/2007 and other dated 15/3/2008, which discloses that she had qualified diploma in medical laboratory technology in the examination held on September 2007 from Northeast Board Allied Health Studies, and the respondent number 9 from Saraigat Institute of Medical Technology. Similar is the stand of the state respondent in respect of these 2 respondents, in as much as the state is silent regarding the acceptance and validity of such certificates and the institute. Accordingly, state respondents are directed to verify the certificate and institution from where the respondent number 8 and 9 had obtained the certificate. And if after verification it is found that on the last date of submitting application pursuant to advertisement dated 19/2/2011, that is on 11/3/2011, the said institution were not recognized, the appointment of the respondent numbers 8 and 9 to the post in question shall be treated illegal, and respondent numbers 8 and 9 be terminated in as much as it was the bounden duty of the employer to verify suspect before appointing the respondent numbers 8 and 9. So, after terminating the candidates whose certificate was not in terms of the advertisement, the resultant vacancy arose, my lord, wherein the petitioner was appointed. But in case of the petitioner also, when the verification was done, my lord, I have filed my affidavit, my lord. In my affidavit, I have enclosed one letter issued by the registrar of the Srimanta Shankardev University of Health Sciences, Assam, wherein, my lord, the list of the medical institutes have been provided which are recognized by the university as well as the Government of Assam, my lord. Paragraph, my lord, 68 is the letter, my lord. And the list is here in the paragraph, page 69. So that institute from where the petitioner obtained her certificate, my lord, this is not in this list. So that institute is not recognized by the state of Assam. And the state of Assam recognizes on the institutes which are affiliated to the Srimanto Shankardev University, my lord. So state of Assam recognizes only those institutes which are affiliated to the Shankardev University of Health Sciences.
Otherwise, it's not recognized.
Not recognized, my lord.
So this,
the institute from where the petitioner obtained the certificate, this is not in this list, my lord, para 69. My lord.
Ganeshguri.
Yes, my lord.
What is the name of that?
That is the name of the...
Medical Technology Research, Ganeshguri.
Yes, my lord.
It is Institute of Medical and Technology Research.
Research, Ganeshguri.
Yes, my lord.
Ganeshguri.
Yes.
So
Lordship,
if it is not affiliated to Shankardev, Srimanta Shankardev University of Health Services,
then it is not recognized by the state of Assam.
Lordship,
And in page 68, my lord, it has
that
been
is-
specifically stated.
Lordship, that
Page
is what I'm trying to
68.
submit.
The
Does the
Institute of
advertisement,
Medical
does
and
the-
Technology Research, Ganeshguri, Guwahati is not an affiliated institute of the esteemed university. It has been specified. And on the earlier round of litigation, only because of on this ground, my lord, the candidature of other students have been cancelled, my lord.
Lordship, nowhere the judgment says mentions SSUHS because SHUHS was not there in the picture in the year 2011. And the list which they have submitted in the affidavit, it lists and close. This is a list of paramedical institute private affiliated to SHUHS. Does the advertisement say that the
advertisement says that
recognized by the government of Assam? And yes, recognized by the, and if your lordship kindly peruses the my certificate at page lordship 20, page 20.
Page 20.
Yes. This is the mark sheet, both this certificate as well as the mark sheet. I'll show. Institute of Medical and Technology Research, Vocational Training Institute for page 20. This is government registered number so and so, registered by Government of Assam based on Central Government Act, affiliated to BSS, promoted by Government of India, affiliation code number so and so.
What is BSS?
BHS is the Bharat Sevak Sangh. This is a institute promoted by the Planning Commission. I'll show the relevant documents. Lordship, first of all, I'll come to that later. Page 21 is the certificate issued to the petitioner.
So what is your submission?
Clearly, Lordship, registered with the Government of Assam. How can they say it's not recognized by the Government of Assam when it is registered with the Government of Assam and affiliated to the BSH, which is a central promoted central government act? Lordship, the Bharatiya Sevak Sangh, if your Lordship takes up page 58. Page 58. The institute is affiliated to this organization. Page 58, Bharat Sevak Samaj is the national development agency established in 1952 by Planning Commission, Government of India to ensure public cooperation for implementing government plans. The main purpose behind the formulation of Bharat Sevak Samaj is to initiate a nationwide non-official and non-political organization with the object of enabling individual citizens to contribute in the form of an organized cooperative effort to the implementation of the National Development Plan. The constitution and functioning of Bharat Sevak Samaj is approved unanimously by the Indian Parliament. Next, Lordship, this is...
According to it, it's not only, it doesn't require recognition by the Government of Assam. If it is recognized by the other, the Government of India, other than the state.
Both, Lordship, my submission is that it's also recognized by the Government of Assam because it is registered with the Government of Assam. The certificates, the documents clearly say that it is registered with the Government of Assam, and that is also one aspect of my submission. It's affiliated to an organization which is set up under by the Planning Commission of India and approved by the Indian Parliament. So
So you are saying that this is the recognized institute of the government of Assam.
Government of Assam.
This is
Yes.
what you are saying.
Recognized.
Which is
Recognized.
the requirement
By of
as
the
per the
of the advertisement.
Yes, you give us the list of recognized institute.
That list is there, my lord. That list,
No, this
They have to give a list as of
this is by
2011.
institute, university.
Date of
My lord,
advertisement.
You place on record the institute, such like institute, recognized of the government of Assam.
Yes, my lord. The institute which are recognized by the which are affiliated to SSUSS, my lord, those are recognized by the government of Assam.
You must be having a list of, government must be having a list of.
Yes, my lord. That
recognized
list is page 69, my lord.
No, this is by institute, your university.
University.
Yes, my lord.
And the
Because
university
only
was
those-
not in
only
existence at that point of time.
the institute, SSUS was established in the year 2009.
Right.
My lord, the institutes which are affiliated to SSUSS, those are recognized because it is a government university, my lord.
Why does not the advertisement say so? That institute has to be affiliated to SSUH. Advertisement does not say
Only,
so.
or
No, sir. That's what I'm saying, sir. You produce a place and record
yes, my lord.
showing that the such like institute, which is being recognized by the government of Assam. This is by the university.
Yes,
Affiliated.
my lord,
Affiliation.
to that effect,
They are showing that I am also included in a list of paramedical institute of Assam affiliated to so and so. This is by the university.
my lord, to that effect, I can file an affidavit that the institutes which are affiliated to SSUSS are recognized by the government of Assam. To that
Yeah.
effect, I will file a short affidavit.
She
my lord.
said that this has been registered and it has been recognized by government of Assam.
Yes, my lord.
You file and be placed on the list of the
Yes, my lord, I
such,
will file it.
institute
Yes, my lord, I will
where
file
the
it.
government is being recognized by the government of Assam. Will it be suffice?
Yes, my
Madam?
lord, I will file it, my lord.
Lordship,
We would like to see which institute the government it falls under the recognition or recognized by the government of Assam.
Yes, my lord.
Lordship.
I will file
Because
it, my
this
lord.
is the list furnished by the University of Health Sciences.
Yes, my lord.
Lordship, the recognition, recognized institute has to be on the date of the advertisement,
Yes.
not
Yes,
as
my
on
lord.
date,
On the date of the advertisement. my
Yes,
lord.
not post
Because
advertisement.
the
Yes.
institute of the petitioner is not recognized by the government of Assam.
Simply you are saying that it's not recognized, affiliated. You said that it's not affiliated, therefore it is not recognized. It is little back.
No, my lord.
Yes.
Therefore, you first, number one, you file an affidavit showing you annex those list of recognized institute, such like institute, huh?
Yes, my lord.
Right?
Yes, my lord.
And then specifically you verify whether this institute from where the petitioner has obtained the certificate
Yes, my lord.
is recognized at that relevant point of time,
Yes, my lord.
not post or
Yes, my lord.
obviously free to
Yes.
not post advertisement.
Yes, my lord.
At the
Yes, my
point of
lord.
advertisement, yes.
Yes, my lord.
Yes,
You
that will
place
do.
that.
That
will
will,
be
that
clear.
will.
That will
To
be clear.
that effect,
Because
yes,
this your this list by the university and health science it's not that
Yes, my
clear.
lord. Yes, my lord. To
It
that
talks
effect,
about the affiliation only,
yes, my lord.
isn't it?
Yes, my lord.
Not the recognition.
Yes, my lord.
I'm not. We are not doubting your submission.
Yes, my lord. I understand.
Once it is
Specifically
not
to that
affiliated,
effect,
it will
I-
not be recognized. That is
Yes.
little, I mean,
Yes, to that effect
indirect.
specifically,
So
my lord.
we want to have a direct opinion.
Yes, my lord.
And the direct
Specifically.
submission.
With that
Yes,
specific about
MS D. Borgoy, learned counsel for the petitioner. Mr.
DP Bora,
DP Bora, learned standing counsel,
Health and Family
health
Welfare.
and family welfare, is granted further 2 weeks time to file an additional affidavit placing on record the recognized what institute?
For imparting certificate in laboratory technician certificate course. For imparting,
List of recognized institute by the government of Assam, where the certificate of laboratory assistant technician is imparted,
yes.
right?
Or my lord, whether the institute from where the petitioner obtained the certificate is
and
recognized
also
by
to-
government or not.
Huh?
The institute
And
from
also
where
to place on record as to whether the, what is that institute?
institute name was my lord.
The Institute of Medical and Technology,
Technology
Research,
Research.
Ganeshpuri, Guwahati, from where the petitioner has obtained her or he,
Her.
obtained her certificate of
Laboratory technician.
laboratory technician is recognized
By the state of Assam.
recognized institute by the state of Assam at the relevant point of time, i.e., that is
Dated 19/2/2011 on the date of the advertisement.
1902,
2011.
Missed after 2 weeks.
God bless you.
Just clarify.
Yes, ma'am.
In item number 40, the state was to file affidavit.
Yes.
So the petitioners are working under respond number 5, my lord.
Who is respond number 5?
I have put a respond.
The service provider.
Actually, what has happened, my lord? The petitioners were under the respondent number 5.
Who is the appointing authority?
It is under the health department.
Respond number 5 is
5 was given. This, my lord, relates to 102 ambulances. In these nurses were there. So initially we were under the services of respondent number 5.
Affidavit filed in which?
No, none not filed. My lord. That is, state has to file an affidavit. My lord.
Yeah, heard Mr. Swenson.
It does.
For the petitioner. Respondents are granted further 3 weeks time to file affidavit in office. This after 3
Deeply
weeks.
obliged.
May I please your lordship?
Yes.
My lordship, the petitioner are the outsourced worker of the PDCL, my lordship. And this is a case for enhancement of remuneration, my lordship.
Who is
The
appearing
last
for
of
the respondent?
PDCL counsel, Mr. was appearing, but today is not here for instruction actually. Today is kept for instruction from the department of PDCL, my lord. The last occasion, my lord. Mr. Patok was appearing. PDCL, no? It was kept for instruction, my lordship.
My lord, the remuneration committee has been reconsidered again, my lord, to consider their cases, my lord. Perhaps the committee will sit again in the last week of November, my lord. So I have this, that is the instruction as of now, my lord.
But then the maintainability of your rate position.
My lordship, actually, this petition is been filed by the outsourced workers for enhancement of the remuneration, my lordship. My lordship, my submission was
Your address, grievance is against whom?
my lordship, my address is against the APDCL department, my lordship.
Yes. It's a department or it's a corporation?
It's a company limited, my lordship, APDCL, my
That's what I'm
lordship.
saying.
Yes,
Is
ma'am.
Is it a state within the definition of Article 12 or other authorities? Whether the writ can be maintained against the company?
Yes, my lord. Yes, my lordship. Because this is the state-sponsored company, my lordship.
Not Mr. Swenson, the counsel for the petition. Mr.
Vidas, my lord.
My lord, may I correct my submission, my lordship?
Vidas, learned counsel for. So if you want to argue on the maintainability, we will hear you before going in. He said your grievances is under consideration.
Okay, my lord, keep
That's
it pending,
why.
my lordship.
That's why. Submits that the grievance raised by the petitioner. No, the grievances of the petitioners. How many petitioners?
My lordship, there are 28 petitioners, my lordship.
Petitioners are under consideration.
Yes,
by constituting a fresh committee.
No, my lord, the same committee has been reconstituted, my lord. This
No.
is
Anyway, under consideration. Therefore, he prays that better may be listed after
4 weeks, my lord.
4 weeks. We have not been objected, will learn counsel for the petition after 4 weeks. On which date, on the next date of listing,
There is an interim order also.
Affiliation cell.
There is an interim order, my lordship. Pendency of the writ petition shall not be barred.
As regard to the consideration that is stated to be under process.
And should there is an interim order, my lord, that will continue.
What is the interim?
Pendency of the writ petition shall not be barred.
That is, we are not vacating it. We will only talk.
Highly obliged.
Yes, sir.
I'm before my laws because my application on the Order 7 Rule 11 was rejected by the learned trial court. Now, you may kindly turn to page 27, which is their claim.
Any records is required?
Pardon, Mala?
Any record is required?
Record, I don't think so, Mala. Because the plaintiff is there, and by having a good look at the averment, it's very clear the plaintiff suit is barred by law of limitation.
Heard Mr. So-and-so, learned counsel for the petitioner, and also heard
MZ borderline.
Respondent admit this for hearing after 3 weeks.
But can a date be fixed?
After 2 weeks, you get 3 weeks.
Because I
3 weeks.
Any date?
No, after 3 weeks.
Any particular date if can be given?
After 3 weeks, you get the date. 21.
21st.
Okay.
Autonomous cycle.
May I? In this
Yes,
matter,
sir.
my lord, we have filed an affidavit in reply to the affidavit filed by the respondent number 4, my lord.
You have filed?
Yes, my lord. My lord, today, my lord, my senior is on leg, my lord, so possible that madam.
Let be fixed for hearing. Pleadings are otherwise complete.
No, my lord, it may be come up for admission now.
Why?
My lord,
Again, it will be come up for admission and we'll admit and again we'll fix for hearing.
my lord,
Heard, Mr.
K,
What is the matter?
my lord, regarding promotion, my lord,
Promotion from what?
administrative officer, my lord.
Yeah. Heard, Mr.
My lord, the K Uddin, my lord, on behalf of P.K. Roy Chaudhary.
Appearing on behalf of
P.K. Roy Chaudhary.
P.K. Roy Chaudhary, the counsel for the petition. You also heard Mr. C.K. Sharma.
D. Bora.
Huh?
D. Bora.
D. Bora, Leonard,
State Government Council.
and State Council. Admit this for hearing after 3 weeks.
My lord, if admitted, my lord, it will not be come up. A date may be fixed, my lord. My lord, a date, my lord. A date may be fixed.
After 3 weeks, give
May it please your lordship.
Yes.
The respondents herein are sought time to file their affidavit.
You are.
No. The
Lordship, I
respondents.
appear for the APGCL in this matter. Lordship, our affidavit is almost ready. Lordship, may you give us.
Heard MS Swenson, Leonard counsel for the petition. Mr.
Lordship, HR Das.
HR Das, Leonard counsel. For respondent number?
Lordship, all the respondents. 1, 2, 3.
Leonard counsel appearing for all the respondents, representing all the respondents. Respondent is granted further 3 weeks time to file it. 3
Lordship,
weeks.
a date may be fixed.
3 weeks.
3 weeks, Lordship.
After 3 weeks, give the date.
Obliged.
Lordship, I have another prayer with regard to item number 16 and 17.
16 and 17.
16 and 17. It is fixed tomorrow, but I'm seeking for, it may be, can it be fixed after 3 weeks?
Why?
As we are need to, as in that matter, we will be filing our affidavit in reply.
16 and 17?
16 and 17.
This is what is the matter?
It is fixed tomorrow as a part-heart matter.
And we'll release it. on the prayer of learned counsel को देखो delete कर देना 16 and 17. Manojit, huh? It was part hard.
Alright. Lordship, a date may be fixed after 3 weeks.
On the prayer of learned counsel for the petition, list this matter after 3 weeks. We have heard you in part and we're fixing the matter tomorrow. You are seeking for 3 weeks. Why you should fix that? Sorry, after 3 weeks, you make a mention if it is not listed.
May I please, Your Lordship?
Yes.
Matter pertains to minimum scale of pay, my lord, and the principle of equal pay for equal work.
Yes.
My lord, last petitioner worked in grade 4 post, my lord, since 2013, my lord.
Yes, well, we have just received our parawise comments, my lord. We would like to file an affidavit. So we will kindly accommodate.
Although this court has granted a last chance to the learned counsel for the finance department for filing affidavit, on the submission of Mr.
Arbor Pujari,
learned state counsel finance department, that he has received the instruction for which he paid for. He has sought for the
finance
2 weeks time to file the affidavit.
Lordship, I apply for the respond numbers 1, 3, 4, and 5. D Bora, so 1, 3, 4, and 5. We have filed the affidavit.
They let this matter be listed after 2 weeks so as to enable the so to file.
Hello, date may be fixed, Lord, if possible.
Mr. So
D Bora, or 1, 3, 4, and 5.
Are you filing affidavit?
We have filed a file, my lord. We have already.
Yes.
I'm so obliged.
Sir, what is this?
Lordship, in this case, Lordship, my lawyer can to file.
My lord, we need some time to obtain instruction.
What is the matter?
Matter, Lordship, the petitioners are Lordship. They have Lordship completed Lordship a diploma in medicine, Lordship, and after that, Lordship, the act under which this diploma course was introduced, Lordship, this act was held as unconstitutional. Thereafter, Lordship, petitioner approached the Honorable Apex Court Lordship, the Apex Court Lordship order Lordship, and wherein Lordship in paragraph 25 Lordship, the Honorable Apex Court says that the petitioners are Lordship, they are allowed to practice allopathy practitioner Lordship. And
yes.
In this legal Lordship, there to notification is required. Otherwise, Lordship, the petitioners are Lordship in departure from conditions.
Okay. Not Mr. Swenson, not counsel for the petitioners. Mr. D. Bora.
DP Bora.
DP Bora.
DP Bora.
That is Standing Council, Health Department.
Yes, madam.
Health and Family Welfare Department. West Foreign is granted further 3 weeks time to file affidavit.
What's the date may be kindly, Lord?
My lord, date may not be given, my lord, because some development is going on, my lord. So it may take, because the issue has been placed in the appropriate level, my lord, regarding the relief sought for by the petitioners, my lord. So it will take some time. So I
3 weeks.
Yes, my lord.
If it's not listed after 3 weeks,
yes, my lord.
you make a mention for listing. Right.
A date may be
Obliged, my lord.
Kindly, Lord.
I
Otherwise,
said if it is not listed,
in last two
if it is not listed after 3 weeks, you make a mention. Right.
Okay, as per official of service is not complete, but respondent
Dwivedi, what is this?
6 and 7, Lordship. Lordship, kindly allow to publish the paper publication, Lordship.
Again, upon
Upon respondent number 6 and 7, Lordship.
the award service report upon respondent number 7. What is the matter?
Matter is Lordship, substitution of legal heirs, Lordship.
The
And Borua, Lordship.
and Borua.
And Borua, Lordship.
And Borua, learned counsel for the petitioner. A petitioner
Yes, Lordship.
is permitted to take steps by substituted mode, i.e., through paper publication.
Yes, Lordship.
In the paper publication for submission, paper publication notice upon respondent number 6 and 7.
7, Lordship.
In 2 daily recognized, what do you call it?
Yes,
In 2 daily newspaper circulated in the locality.
May I please, Your Lordship? Lordship, with regards to the respondent number 4, we have not received any instructions regarding whether there are any other legal heirs or not, Lordship. And with regards to respondent number 2A also, Lordship, we have not received any instructions. Lordship, therefore, this matter may come up after 3 weeks, Lordship.
On the prayer of
N. Brahma, Lordship.
learned counsel for the petitioner, list this matter after 3 weeks so as to enable him to take steps. Mr. So-and-so,
Your Lordship. For respondent number 4 and 5.
respondent 4 and 5. Huh?
4 and 5.
Respondent number
4 and 5. Your Lordship, the respondent number 4 is expired. It has been informed on the last date.
If he is expired, how can
Respondent number 5, Your Lordship. Respondent number 5.
Who has to file the take steps for substitution?
The petitioner.
Mr. So-and-so for respondent 5.
Deeply obliged.
May I please, Your Lordship?
Yes.
I am appearing for all the respondents. Service already completed. LCR also received. Kindly fix a date for hearing.
None appears for the appellant on call. You are for respondent.
Respondent, all the respondents. I am appearing on behalf of RS Mishra.
Mr. So-and-so appears for all the respondents. This is the matter for hearing after 3 weeks, 4 weeks.
Yes.
Lordship, as per Lojima order, Lordship, last order, we have to take first step. Morning, I had made a mention to take the first step.
Lordship, can you see the Lojima order, Lordship? No, Lordship. Lordship, can you see the Lojima order? 27/9/24, Lordship. For 5 years, Lordship, they are not taking steps in IA.
No, Lordship.
Yes.
For the above, it appears that petitioners are not intends to pursue the matter, pursue in this case, Lordship. Lordship, earlier Lojima, there are lots of Lojima order, Lordship, 21/8/24, 15/7/24. They are not appearing and they are not taking steps because this, due to the IA, Lordship, the injunction order has been stayed. Then I have also
You
filed
are
one.
appearing for what? Whom?
I am appearing for respondent, Lordship.
All respondents?
No.
No, one only contested respondent. All others are performer respondent. And regarding this, Lordship, I have also filed in IA, Lordship. In my IA, Lordship, there is a order to hear the my IA in admission column, Lordship. Till today, I am filing 2019, Lordship. Till today, it has not been listed, Lordship. It has been hard, Lordship. Kindly see my IA number, Lordship.
Which one?
2134. 2134.
2134.
In CRP number 99.
There is no IA.
Yes, there is two.
There is one IA, Mantu Roy. Yes.
That was filed by that.
3941.
No, both have been listed today, Lordship.
It's not here. It's here.
Along in 99, yes. 2134. 2134.
2134.
2134. CD, can you see the order at 12 to 2020?
Yes, then
Service is completed in this IA, Lordship. My IA should be hardly in administrative. My IA is there. They are filing. They appellant and respondent. They have filed that. Who are going to file appeal, Lordship? IA. Both same person, Lordship. Appellant is same. Respondents are also
what
same.
is your IA?
My IA, Lordship. My IA is that said in this case who have filed appeal, Lordship, CRP, Lordship. The same and similar person in the respondent, Lordship. I have produced a voter list, Lordship, that they have made party, they are appellant, Lordship.
We'll consider next.
Yes, in the
I'm
admission,
not
Lordship.
getting anything.
Lordship, in the admission column, Lordship, so there is an order, Lordship. My
Let the steps be completed.
Lordship.
You wait for some time since you are waiting for since 2019.
Lordship. I think. Your stay order is there, parting.
Yes, wait for some time. We'll see. We
6
consider
years stay order is there.
on the Mr.
SSR.
Counsel for the petitioner.
Moreover, Lordship, he has not filed Kalanama. I may pray that he filed Kalanama. Otherwise,
Lordship is permitted to take steps, press steps upon respondent number.
Respondent number, opposite party number 1, 2, 6, 7, Lordship, 3, 4, 5, 10, 11, and 12.
Mr. Mahanta.
D. Mahanta.
Then counsel for the opposite party, respondent number 1. Opposite party 1. Respondent number 1 is present.
In my eye, Lordship, T1, they are also right. Because it should be hard, Lordship. 6 years, Lordship, I am waiting for it. There is already order.
Yeah. 2134.
2134.
Heard Mr.
Demont.
Respondent, opposite party.
Lordship, that I have not filed my Wakalatnama, but on the second case, Lordship. First time appearing.
But you are a party.
Yes.
Party.
Yeah, it's okay.
Objection is filed.
Objected to that. That's right.
Mr. Roy is granted 3 weeks time to file objection.
Objection has been filed, Lordship.
Filed.
Filed, Lordship. Earlier party.
Let this matter be this. Let this matter be listed after 3 weeks.
Lordship.
All right.
Lordship, in this case, Lordship, we have taken steps, Lordship, due to deficit code 3, Lordship, it was not served. Lordship, kindly allow me to rectify the deficit code.
Yes. What do you say?
Lordship, due to shortage of Lordship court fee, the notice could not be served upon the respondent by the registrar. Lordship, kindly allow me to rectify the defect.
Mr. So-and-so, counsel for the petition, appellant is granted 3 further 2 weeks, granted a week's time to take appropriate steps.
I for respondent of 3.
Mr. So-and-so. Ketia?
Is this like Lordship?
Huh?
Is this like Lordship?
Is this okay? Sorry. Then consider the respondent number 3 is present. Yes.
Lordship.
Service reports for further 2 weeks. 3 weeks.
Lordship, interim order may be continued.
Interim order for service.
Obliged.
My please, Your Lordship. My Lord, service report of respondent number 2 and 6 awaited, my Lord. Other completed.
Upon respondent number 2 and 6.
2 and 6. Other completed, my Lord.
Further 3 weeks.
I'm appearing for respondent number 1 and 4. We have
MS.
Amber.
Learned counsel for the learned counsel appears entered appearance and they have respond number 1 and 4.
1 and 4.
And Mr. 4 7. 2 and 6.
2 and 6, then complete, my lord.
2 and
Then,
6.
then complete, my lord.
This is 1 and 4.
1 and 4.
1 and 4. 1.
One and 4 directly. Commissioner.
Madam, you make
Lordship,
yourself
1
which
and 4.
1 and 4.
1
Then
and 4.
7. Then 2 and 6. What about 3?
3, my lord, appeared Mr. P. Nayak and H. Oli, already, my lord, mentioned
And
in the
then
first
5.
list. 5, my lord, Mr. B. Deuri.
So all represented.
All represented, my lord.
The service complete. Services are completed. Service complete in respect of all the. Just right, service complete. List after 4 weeks.
Lord, it's a pension matter. Can it be fixed, my lord?
List after 4 weeks
4
to
weeks.
enable the respondents to file the affidavit. After 4 weeks, you just fix it.
Ambulance.
Highly obliged, your lordship.
May I please, your lordship?
Yes, sir.
Time. Time.
Sir, I'm praying for some accommodation, Lordship. Kindly next week candidate, Lordship.
Why?
In that case, well, I have no objection for granting time. But in that case, the execution case, they have already started. That execution case may be stayed till that.
Number 1. Sir, in that case, you will have to file an application.
Madam, till then,
The matter can take next week any date, sir.
no, madam. What happened is this.
What is this IF?
IA is for the continuation of delay. With 264 days delay.
So have you filed the
Yes,
objection?
they have filed objection.
Next week, we'll take it up next week.
Till then, the execution of the decree may
That
be
will
stayed.
take up.
Till then, the execution of the decree may be stayed.
Then you undertake. You will not.
So they have to file a proper application for date, Lordship.
No, application is not necessary because we filed petition, they filed their
When is the
reply.
next date fixed? Execution, when is the next date fixed?
It is date is not fixed. Any day the Nazir can go and kick me out from the place.
So day after tomorrow it can be taken, Lordship.
As and when.
My lord, the
As and when that is fixed, or you may file an appropriate application.
17/12/2024.
Then you file an application.
17.
File an IA so that we can consider your prayer for stay of the execution. Normally, we would not like to stay the execution, but then if you file an appropriate application, we'll consider.
My lord, I have my petition for condemnation of delay may be considered.
No, she is seeking time.
Because I have no objection for seeking that, but till then, the decree.
Till then, for that, sir, you will have to file an application.
The court has the ample power to grant that.
It's also a civil revision petition.
Civil
We
revision
don't
petition.
know. Are you
Your-
challenging? Sir, are you challenging those execution petition?
Yeah, we are challenging the decree.
Decree, you are changing the decree. First, we will have to condemn, then only we can pass an interim order.
My lord, your
Next date is fixed on 12th December.
17th,
We have filed a petition in the executing court informing that we have already challenged the degree in the High Court.
So how
by
many-
filing a petition, and the next date is fixed for submission of the copy of the order passed by any High Court, and the decree order is directed to proceed with the execution.
When is the next date?
That's 17/12. If in the meantime they put into execution of this case, our petition will become infructuous.
First, we'll have to hear, condone the delay, then only do we
There
can
is
pass an
there
appropriate
is a
order.
judgment of our High Court which says it accepts certain circumstances, the court without condoning the delay can stay the execution of the
So
case.
let's you can see.
Why you are seeking time?
My senior, sir, because of some personal difficulty.
Next week.
If
Sir,
there
next
is-
we'll take it up next week.
If there is no pendency of the execution, we will be not pressing for hearing of our matter, Lordship.
Sir,
Since-
if unless the delay is condoned, how can we pass your civil revision petition? It's not
There is a
tempered
judgment,
at all.
Lordship. There is a judgment of
My
our
lord,
High Court.
the Learned, your lordship has the ample power to state, because there is a judgment from our High Court.
Next
High
week,
Court.
we're considering next week. Next week,
Any date, yes,
we'll hear you on condemnation because you are serious objection.
Lordships. We have filed objection. Lordship. There is objections.
Next week, sir.
264 days a week.
Only 264 days.
Sir, you are not objecting to his prayer. You are only seeking stay.
I am only seeking a.
And when I am asking that when is the next date is fixed for execution petition. When it is fixed?
Tell my lord, it is fixed up.
Mr. Sir, we'll fixing it.
A.C. Sharma.
A.C. Sharma, learned counsel for the petition.
Yes,
Learned
correct.
senior counsel.
Yes.
Assisted by
B. Haldar.
B. Haldar, learned counsel for the applicant. Mr.
A. Dhanuka. A. Dhanuka.
A. Dhanuka, learned counsel, appearing on behalf of
A. Ganguly.
A. Dhanuka, learned counsel for the petitioner. The opposite party respondent submits that Mr. A. Ganguly, learned counsel who is leading in this matter. Who is appearing for, who leads him in the matter as respondent number 1 and 2. For respondent 1 and 2, as some personal difficulty for which he prays for listing the matter after a week. Prayer not being objected to by learned senior counsel for the applicant.
After tomorrow.
Let this matter be listed after a week.
Can it be on 5?
5 so many matters were fixed. What do you say? 6, make it 6.
6 will be. not
6 will be out. On 5th, my lord. On 4th or 5th.
Kindly, Lordship.
On 5th, on 6th.
Otherwise, we have more.
Make it 5th.
Either.
Me,
Yes.
I have filed one appeal.
This is for
And in
what?
filing
IAS for
that,
what?
there is a delay of 69 days.
Will issue notice?
Yes.
Or Mr.
A. Bhattacharya.
and counsel for the applicant. This is an application under Section 5 of Limitation Act 1963. Praying for condemnation of delay of 69 days in filing the connected MFA against the judgment and order dated judgment and award dated 04/05/2024 passed in EC case number 18 of 2022 by Commissioner under Employees Compensation. Golaga. Issue notice returnable by 4 weeks. Listeners to the applicant to take steps for service of notice.
All right.
My limitation is barred by only 17 days, my lord.
But will issue notice. Had a missions and counsel for the petition. This is the application under same, huh? Section 5 of Limitation Act, praying for condemnation delay of 17 days in filing connected appeal against the judgment. Connected MSC appeal against the judgment award dated 18/5/2024 was the MSCT. Number 1, MSCT, number 1, complete within the and bracket plus in MSC case number 1982 of 2016 Issue notice return within 4 weeks. Applicant to take state for service of notice.
Oh, bless me.
There is a delay of 129 days in filing the MSc appeal.
So same. Application under section 5. Praying for combination of delay of 129 days in filing the MSc, connected MSc appeal against the judgment awarded in 19/1/2024. Was in MSc case number 349/2020. By MSc. Come on, what better?
What better?
Issue notice returning by 4 weeks. The applicant to take stage for service of notice upon respondent. How many respondents?
Third, four,
By
five.
registered,
Five responses.
Respondent by registered person.
Lovely. May it please your lordship. Lordship, IA number 3239 has come up for delay of condemnation of 69 days, your lordship.
Yes. First time.
Yes, your lordship.
Notice. Notice.
Yes, your lordship.
Administration for receiving application under section 5 for praying for condemnation of delay of 69 days in filing the connected MSc appeal against the judgment and order dated 28/03/2020 passed by the MSc Iran in MSc case number 06 of 2020. Issue notice returnable by 4 weeks. The applicant to take his stage for service and notice of
May please give me, Lord. Lordship is condemnation delay petition first time lordship, so notice may kindly give me.
Lordship, I'm for respond number 1, ASTC. On behalf
who is the main party?
ASTC lordship, government.
Do you have any objection?
Yes, Your Lordship, 3 weeks' time may be given to us and a copy may be
Why?
furnished. We want
Any
to file-
objection?
We want to file objection.
78 days only lordship.
Or Mr. Argosam.
AR Agarwal.
A.R. Agrawal, learned counsel. He has objection.
We'll file
Next,
an objection.
application under section 5 of Modification Act 1963. Praying for condemnation of delay of 78 days in filing connected MSc appeal against the judgment and order award that 2012-2020 passed by MSc. Come on, Golfara in MSc case number 44. Issue notice the respondents. Next, Mr. MS Swenso.
K. Bhattacharya.
Appears on behalf of
GN Sahibala.
Respond number 1.
Yes, Your Lordship.
ASTC.
Yes, Your Lordship.
Appears and accepted notice on behalf of opposite party number 1. This for day for performing the so respond number 1. Legal to take stage for service of respondents 2 and 3 registered for 3 days.
Main petition to like file to
This after 4 weeks. Yes.
Let's see in this matter, the Commissioner Panchayat and Rural Development Assam forwarded a letter to the Government of Assam Panchayat and Rural Development Department for instruction. So need 3 weeks time may be done.
My lord,
what is the matter, sir?
16 matter, my lord, 2016 matter, my lord.
Yes.
He is now is dying.
What is your case?
The matter is, my lord, the petitioner was a peon of rendering the service as peon in the PNRD department, my lord. He was suspended, my lord, in the year 2005, my lord, for unauthorized absence. And retired from service on, my lord, December 2015, my lord. Thereafter, my lord, in the year
Suspended.
2016, suspended, my lord. In the
No
year
departmental inquiry.
no inquiry, no
Nothing, only
suspension and nothing is there.
suspended and allowed to retire.
My lord.
Is it so?
My lord, without disposing the suspension letter, the petition was retired from service. This is the minimum modified value. So, my lord, it pays for all consequential benefits. My lord. This is my
Why 2016 method you are
No, Lordship, but in 2018, I have filed affidavit.
saying what?
Here say,
my lord,
Place the output instruction as because the status of petitioners, aerial and salary and pension on the next date of listing.
that on 14/10/2022, my lord, submission of the pension proposals in respect of Sri Gajendra Patgiri and retired peon of Bajali AP.
The matter is forwarded to government for favor of information and fairness. Was there any inquiry? No.
Lordship, for that, we need to time.
You could have.
Lordship, kindly say in our affidavit, here said,
Yes, there is a direction of this code on 29(8).
Lordship.
Heard Mr.
Bislam.
Bislam, learned counsel for the petitioner. MS
Anbora.
Enbora, learned counsel for the
Yeah.
standing counsel for
Yeah.
PNR department by placing the communication dated 24/10/2024 semester. The concerned authority has provided the matter to the government for necessary instruction. Therefore, see, President, matter may be listed after. It may be granted some more time to place on to obtain. You look at it, page 28, 29, huh? Order to place to obtain instruction as directed by this court on 29/08/2024. Look at it, you get the order and
Lordship. Lordship, and for response number 3.
administration learn concept is fair. Although this code is not inclined to grant further time as the matter is of 2016. And as a last chance, MS Enbora is granted 3 weeks further time to obtain instruction placed on the court.
Yes.
It is made clear that no further adjournment shall be granted. Shall be granted on the next day of this. No further adjournment. 2016.
Let me fix that.
There is an appeal, my lord, against an award of Employees Compensation Act, my lord. I am for the respondent, my lord.
Who is called petitioner?
My lord, petitioner, my lord, his name has been shown, my lord, not appeal. And there is a blanket stay, my lord, without, my lord, directing them to deposit anything, my lord, stay has been granted, my lord.
S. Chakraborty.
That way, my lord, the date may be fixed, but
You are for respondent.
for respondent claimant, my lord.
What is the ground of challenge?
Ground of challenge is, my lord, there is basically, my lord, there are all hypothetical grounds, my lord. Otherwise, it's there are lots of grounds, my lord, they have stated.
Or will dismiss?
My lord, can be, my lord, because he has the knowledge, my lord, because by order, my lord.
Will dismiss for default?
My lord.
For non-prosecution?
My lord.
It's MFA.
MFA, my lord, lordship can, my lord.
Non-appears for the appellant on call. Next, Mr.
P. Chundi.
P. Chundi. Now, counsel for the respondent.
Respondent.
Only.
Respondent number 1, my lord.
Respondent number 1 is present. Although the metro was listed today on the consent of the counsel for both sides.
My lord, it can be fixed, my lord, next week, my lord, any hearing day, my lord. Possible.
As a last opportunity, let the matter be listed after 3 weeks.
Well, can it be, my lord, date may be fixed on hearing date, my lord.
On as a last opportunity, as an opportunity, as a last opportunity to the appellant. Let the matter be listed after 3 weeks on 21st, 11.
Much obliged.